Yeah, very true. Yeah.
Yeah, whichever side doesn't.
I don't think Johnson did. Well,
Give them a diversity of style.
yeah, but
He'll be out in a minute. Did you know if Ellen is? Did you see she could change the class to the same?
who are we talking to on Friday afternoon? Okay. I clicked on it so fast when I accepted it.
All rise. Fourth District Court for the City of Utah is now in session. The Honorable Derek Pullen presiding.
Good morning. Thank you. Please be seated. Can we have Mr. Carter out, please?
We're joined by our mitigation specialist. I wonder if he can join us.
The court will call the matter of State of Utah versus Douglas Carter. Mr. Carter is present with his counsel. The state's lawyers are present. Would you state your appearances, please?
Good morning, Your Honor. Erwin Patilos, Stephen Jones, and Peter Reichman for the state.
Neil Hamilton appearing alone for now for Mr. Carter. Mr. Gale will hopefully be joining us as the day progresses.
Are you ready to go without him?
We are.
Thank you. We are scheduled for hearing today on 3 matters: defendant's motion to suppress confession, the state's motion for DNA samples to be given from Mr. Carter, and finally, Mr. Carter's motion to address bail. I'd like to take those motions in that order. So let's begin with the motion to suppress.
Your Honor, that order is fine with me. I just have a witness here from the lab who needs to testify to some things that pertain to the DNA motion. Would you rather take that testimony now and get the witness out of here, or would you rather take that testimony just before we get to the DNA part of it?
Does the witness have other commitments today?
My normal work duties, but
It's fine then, Your Honor. Let's proceed the way the court intended.
Very good. Mr. Hamilton,
In your honor, would you prefer me to argue from counsel table or from the lectern?
wherever we can get a good record, if you're going to stay seated, just make sure the microphone is in front of you.
How are we doing? We're good? Okay. In your honor, I'm not going to argue that much on the motion to suppress. Our initial motion was ponderous. I will admit to that. And the state's response only focused on one issue, the issue of issue preclusion. So I take that as a concession as the rest of the points, and kind of a signal that we should really focus on issue preclusion and on whether or not Mr. Carter gets to re-raise this issue. And on that issue, I think the answer is pretty clear, that we acknowledge issue preclusion. You know, we don't just keep having another bite at the apple. That's not how this works. But when there is new evidence and the issue has not been fully and fairly litigated, the law is clear. We get another crack at it. The goal is fundamental fairness. And in this case, fundamental fairness has not been achieved on this issue. Mr. Carter asked to suppress his confession in 1985, and he again asked to suppress it in 1990. In 1990, additional evidence came to light. Particularly, they learned about the destruction of the audio recording that was made of Mr. Carter's confession, and that issue was revisited. Now we have a lot more information that has come to light. To begin with, we have the studies and the findings that have been done about Mr. Carter's susceptibility to coercive interrogation. That first came to light in the late 1990s, and when that issue was brought before the federal court in Carter versus Bigelow, that court said that the state court needs to first weigh in on this. because Mr. Carter's susceptibility to coercive interrogation had never been fully and fairly litigated in the state. The next evidence that is new is evidence pertaining to Detective Lieutenant Pierpont's credibility. Mr. Carter testified in 1985 that the only reason he agreed to sign Detective Pierpont's confession was because of the threats that were made to his friend. Ms. Robbins was there, she took him in, and she was arrested with him, and Mr. Carter was told for 2 days that she was going to be charged as an accomplice, that she was going to be arrested, and that her children were going to be taken away. And Mr. Carter was very clear that the only reason he agreed to Pierpont's confession that Pierpont dictated were because of his concerns for his friend. Pierpont denied that at the suppression hearing. And so we're left away the competing credibility claims. Now we know that that is Pierpont's MO. We know that he threatened Ann Carter during the initial interview, even though the transcript shows that she was nothing but cooperative. He characterized her as uncooperative and threatened to charge her as a co-conspirator. We know that he threatened the Tovars, Epifanio and Lucia. He threatened to charge them as an accomplice. He threatened to deport them. He threatened to take Lucia away from Epifanio. He threatened to take their son away. And Epifanio testified that Pierpont threatened him with the death penalty if he didn't do what he wanted him to do. We also know that Pierpont threatened Perla, that she was scared when she talked to them, and that Pierpont threatened to take her kids away. This is information that was not known. And it's important. It allows us to properly weigh Pierpont's credibility, because his credibility is the only thing that stands in the way of this court's finding of voluntariness. Pierpont has previously testified that the confession was voluntary. And even though the Utah Supreme Court found significant issues with how the confession was taken, they upheld it because of the corroborating evidence from the Tovars. And now that foundation has been undermined. And all the information undermining that credibility is brand new before this court. Additionally, we now have the DNA evidence. We know that the DNA blood evidence was found at the crime scene, that we will hear later on when our investigator testifies, that there is a substantial likelihood that that blood came from the murderer, that there's a substantial likelihood that the murderer cut himself on the knife and left his blood at the scene. We know that that DNA profile has been compared against CODIS twice. We know that Mr. Carter is in CODIS, and we know that there are no matches. Now, we know that that is not an exclusion, that there's more that needs to take place before we have a legal exclusion.
How does that evidence bear upon the voluntariness of the confession?
I think it bears upon the voluntariness when you consider the overall credibility. When we consider that, Lieutenant Pierpont was putting all this information onto Mr. Carter and doing it in the claim that Mr. Carter was there, that, of course you knew what happened, you were there. And now we have evidence that says he wasn't there. So when we're talking about the voluntariness of a confession, I think that what evidence of exoneration, evidence that shows that Mr. Carter was indeed not there, is absolutely germane to the question of voluntariness, because you don't usually confess to things that you didn't do. And here we have evidence that suggests strongly that Mr. Carter did not do this.
You have evidence that someone else was there. You don't have evidence that Carter was not there, right?
Correct. We have evidence that everything suggests is connected to the murderer. That Ms. Olesen's murderer cut their hand, well, his hand. We know that it's male DNA. And we know that there's blood evidence that was found at the scene. And the DNA profiles that were run against CODIS came from this blood evidence. The pillow that officers have already established was used to muffle the fatal shot, a palm print on the back door. And that is probably the most important evidence to us, because there's only 2 profiles for that palm print, Ms. Olesen's and the unknown male. So that evidence, that bloody palm print left on the back door, is, I think, what we can all point to and say that is definitely the murderer's blood. and the DNA profile from that evidence, as well as the blood found in the alleyway next to the fresh shoe print, was run against CODIS, and there wasn't a match. And I think we have every expectation that if it was Mr. Carter's DNA, we would have a match, because we know they have his profile. So I think that overall goes to the totality of the circumstances surrounding it. And that is the consideration that is made when we consider the voluntariness of a confession. We consider the whole thing. And this evidence, I think, absolutely goes towards the totality of the circumstances surrounding Mr. Carter's confession. Mr. Carter has always maintained that he didn't do this, that he was framed, that others witnesses were coerced, and that Mr. Carter is not the person that took Ms. Olesen from her family. And now we have evidence that confirms that. And so I think that the state's objection is not well taken. And we acknowledge the court's concern that Your Honor has raised previously about language found in Carter 6. We acknowledge that, but I think it's important to realize that that language was not, it didn't come in a vacuum. That language was specifically discussing the PCRA proceedings. And here we have, when Mr. Carter previously asked for bond in 2023, the Attorney General's office filed a response, and in that response, they characterized his confession as unchallengeable. And I think that characterization was correct for the purposes of the post-conviction relief action. And I think that's the important framework that we need to look at the Supreme Court's decision. Under Utah's Post-Conviction Relief Act, we don't have the ability to suppress a confession. The only thing that the only option the court has before it in a PCRA action is to reverse the sentence or reverse the confession, or the conviction, my apologies. Challenging the admission of individual pieces of evidence is not permitted under statute on a PCRA action. And so when the confession was brought up during the PCRA, and I apologize for telling Your Honor what you sat through, I wasn't there. But when that confession was brought up in that context, it was brought up regarding the strength of the remaining evidence. It was the state that brought up this confession. It was not Mr. Carter. It was the state that pointed to the confession and said the remaining evidence is strong, and so the overall harm is minimal. That was the context that it was brought up, and the state continued to call it unchallengeable, unchallengeable. And in that context, it was unchallengeable. But we are not in PCRA anymore, and it is challengeable today.
How do you, well, maybe that's your answer, but in the PCRA case, the court states that in reference to Pierpont's bad acts, they do not renew questions about the confession's admissibility as an evidentiary matter.
And I think that language, Your Honor, again, we look at that as their analysis under the PCRA Act. The court is bound by the laws. And I think that is an acknowledgement that the laws the court is bound by. And Mr. Carter's PCRA counsel didn't take that confession that assertion that was unchallengeable lying down. They fought back, and they pointed out the problems with that confession. But the ultimate finding was, yeah, the confession is unchallengeable for this hearing. But overall, the strength of that confession is significantly undermined by the misconduct involving the Tovars. And so I sincerely believe that when the court mentioned that, when they used that verbiage, it was an acknowledgement of their statutory restrictions under PCRA, that they really can't do anything about it there. So although they acknowledge their problems, and the same issues that we're raising today were raised by counsel on the post-conviction relief action. And I think that is an acknowledgement that we acknowledge there are significant problems with this confession, but not for today. Because under PCRA, the only thing that the Supreme Court or this court or any court considering the action could do was overturn a conviction and resentence. And so I think that context is honestly the answer. We absolutely acknowledge that verbiage. We acknowledge the overall input and the overall impression that verbiage gives. But I think the contextual analysis is important. And as we go back into Carter 4 and Carter 5, that contextual analysis was expanded. In Carter 4, they talked about, sorry, I'm going to flip through to answer that question because I know it's got it highlighted. But in Carter 4, they talked about the analysis being for PCRA purposes only. And in Carter 5, they did it as well. They talked about it's not challengeable for this hearing. They never said we can't revisit it, because frankly, that's not the case, because Mr. Carter did revisit that confession in 1990. When the evidence came forward about the tape being lost or destroyed, they revisited his motion to suppress. It was heard, and it was again brought up before the Supreme Court in Carter 2, where they said, we don't think this undermines confidence in the voluntariness. So this is an issue that has already been litigated. And if what we were doing was not permitted, I think that the state's argument would have been brought up by the Supreme Court in Carter 2. And it wasn't. In Carter 2, they considered it, and they said, well, the destruction of the tape really doesn't change the voluntariness consideration or the totality, so they denied it. And then they upheld the resentencing. So what we are seeking, what we are trying to do, has frankly been done. And the court reviewing it did not raise concerns with the district court previous judge's allowance of a new suppression hearing.
Do you know if the state raised the concern of the mandate rule at that time?
I do not. I looked in briefing, and I couldn't find it. Unfortunately, the exchange is not that helpful, and we were not able to get the original briefing on the renewed motion to suppress. But again, reading the decision, I would imagine that if it was raised, if this objection were raised in 1990, that it would have been raised on appeal, and it would have been one of the issues dealt with before the Supreme Court in Carter.
And that's my last question for you, is that the district court can't run afoul of the mandate rule. And right now, the law of the case in Carter is that the confession is admissible. It's been ruled on twice. Doesn't the mandate rule require me to just accept that? And if this issue can be raised again, it's for the Utah Supreme Court to address it on interlocutory appeal.
I don't think that is the case. I mean, the first
Do you have any case that would suggest that the mandate rule, and it's at least the exceptions to the mandate rule, can be applied in the district court?
Well, I mean, we have the history of this case where that has happened before when it was brought up, and we also have the practicality of the matter. The Supreme Court doesn't have the ability to take evidence. The district court does. And so introducing the evidence and creating the record, that is what happens down here. The Supreme Court reviews what happened down below. Under Taylor versus State and under State versus Ruby Mills and under Utah Code, the law is clear that in a criminal case, newly discovered evidence that is material negates issue preclusion. And so we acknowledge the state's point of that only the Supreme Court can overrule the Supreme Court. We are not asking Your Honor to overrule the Supreme Court. What we are asking is to follow the clearly established law regarding issue preclusion and the exception. And the exception is clear. When there is newly discovered evidence that's material, it negates issue preclusion. And here, there's already a finding that this newly discovered evidence is material. It was that materiality determination that led to Mr. Carter's PCRA conviction to be successful. So we know that the evidence of the misconduct, the police and prosecutorial misconduct, is material. So we've satisfied that. But fortunately, that's not the only exception to the mandate rule. there is the fundamental fairness consideration. The question isn't whether or not a hearing has occurred. The question is whether that hearing has been fair, fully and fairly litigated. And here, we know it hasn't, because that determination was not made in light of all the evidence we have now. And I hate to say it, but I'm fairly confident that we still don't know the extent of what happened. But what we do know occurred directly pertains to the credibility of Pierpont. And it directly pertains to whether or not he did threaten Ms. Robertson, to whether or not he did tell Mr. Carter that if you don't confess, she's losing her kids and she's going to go to jail alongside you. Mr. Carter raised that in 1985. Pierpont denied it. Now we know that that's actually consistent with what he did with other witnesses in this case. And I think that materially undermines his credibility, and his credibility is honestly the sole issue upholding Mr. Carter's confession. This isn't a case where Mr. Carter sat back and said, here's what I did. Pierpont told him what he did, and Mr. Carter agreed. So this is not a confession in the traditional sense. Mr. Carter never stood up and said, this is what happened. Pierpont acknowledged during the 1985 evidentiary hearing that he would dictate what happened, and Mr. Carter would then turn and agree. And Mr. Carter has always been clear that he never said he did these things. Pierpont told him, this is what you're agreeing to. And so now we have this new evidence that is material that undermines that credibility. And under the exceptions to issue preclusion, this falls squarely in line with those exceptions.
Okay, anything else?
Not unless Your Honor has any questions.
I do not. Who will argue for the state?
Your Honor, the issue was first litigated in 1985, and the admission was found to be admissible. The issue was then
The
again...
confession.
The confession, I'm sorry. The issue was again litigated in 1989 in front of the Supreme Court, and the Supreme Court said that the confession was voluntary and that its admission was not in error. The recording was destroyed in 1990, and then in 1995, the confession was litigated again, and the Supreme Court...
In the district court, correct?
Correct.
So,
Yes.
and how did that happen? If the mandate rule, I mean, you understand the argument. How
I
would
do.
that have happened in the district court if the mandate rule precluded it? How
Honestly,
did
Your
we
Honor,
get
there's
a...
all sorts of things that happen in the district court that are not proper procedure.
How so? What do you mean?
District courts do things that are found later by the Supreme Court to have not been proper, and just because that happened in the district court doesn't mean that it was proper to do that in circumvention of the mandate rule.
Wouldn't you then, at the Utah Supreme Court on appeal, have the court say, the district court violated the mandate rule. We've already ruled on this, done. But that's not what they do. They reach the merits, right?
That's true, and
How should I interpret that?
I'm not sure you should interpret it, because the mandate rule clearly stands. It's still the law. And just because this particular procedure was engaged in 1995 does not mean that it was a proper procedure.
Well, one explanation for it is that the mandate rule operates with its exceptions in appellate courts, right? So by the time you get to the Supreme Court, it's the Supreme Court saying, we have discretion to examine this again, and we choose to.
Sure.
I think that's probably the best explanation.
That's fine, Your Honor. That being said, I still believe that the issue is precluded. It's been litigated on a number of occasions, and the confession has always been found to be admissible. It was found again to be admissible, or at least it was opined upon in the post-conviction relief litigation. And I'm not going to read the court's quote back to the court, since you've already quoted it and you're clearly aware of what that litigation involved and what that litigation stated. But this confession has been litigated on a number of occasions. It's always been found to be admissible, and the mandate rule requires that it be upheld. And as far as fundamental fairness is concerned, it's also part of fundamental fairness that issues not be litigated over and over and over again ad infinitum. There has to be rule of the case. There has to be res judicata. There has to be a stable platform on which people can stand, and that's why the mandate rule exists. As far as new evidence is concerned, two things. When the defense asserts that Mr. Carter was threatened with the arrest of his friend and her loss of the child, first of all, that's not the kind of activity that causes a confession to be involuntary. Second of all, I don't believe that was a threat. I think that was a plain language statement of what was going to happen, because reading in the police reports, the friend was subsequently arrested for harboring a fugitive, because she was harboring a fugitive, and the child did end up in foster care because once the friend was arrested for harboring a fugitive, there was no other place for the child to go. So I'm not sure that that's really a threat, because it's actually what happened. And it didn't become a non-issue because of the defendant's confession. It was just a statement of what was going to happen. And someone who's harboring a fugitive is always going to get filed on. Also, as far as the threat for deportation on the Tovars, that's completely nonsensical. The Tovars were trying to get back to Mexico, and after this case, they did go back to Mexico, and they've stayed in Mexico since. So how is it a threat to carry out a change of location, which the Tovars wanted, which the Tovars executed themselves after the trial, and to a place where the Tovars have stayed the entire time afterwards? It's not a threat to say, we're going to send you to Mexico. If you actually want to go and live in Mexico, that's no threat at all. As far as the DNA evidence is concerned, we'll take testimony in a while that multiple unknown male profiles were found at the location. Some of those profiles were uploaded into CODIS, and there was no CODIS hit.
What have you tested exactly?
Mr. Yankee will testify to it, but one of the things that was tested was the blood that was in the snow outside the home. So it was actually outside of the crime scene. There was something else tested which turned out to be actually familial DNA. We received DNA from Eva Olesen, and one of the things that was tested turned out to be familial to Eva Olesen. You'll hear testimony from...
Sorry, what have you tested? So the snow outside?
The snow outside, the doorknob, there's the waistband of the pantyhose.
This is the screen door?
Correct, the
Okay.
waistband of the pantyhose.
I'm sorry, the door, when you say the doorknob, is this what's been referred to? That's part of the problem, is we call these things different things, and it's hard for me.
Yeah, absolutely, Your Honor.
Is it the screen door?
I don't believe it's the screen door. I think it's the actual doorknob to the door. But
Okay.
that's why I wanted to take Mr.
Yeah.
Yankee's testimony even prior to this. And rather than taking the risk of misspeaking, I'd rather wait for his testimony so that that's all very clear.
So you've tested many items of evidence, and what's
And
in
there are multiple unknown male DNA profiles.
Okay. And
A subset of those unknown male DNA profiles were uploaded into CODIS and resulted in no CODIS match.
okay,
However, there are still unknown male DNA profiles which were not susceptible to uploading into CODIS because of the CODIS requirements, but are robust enough to test against a sample of DNA from the defendant should the court grant that motion.
I see. Okay. And again, I'll ask you the same question. How is that relevant to voluntariness of the confession?
It's not, Your Honor. I'm only bringing that to the court's attention because when defense was arguing, they made it sound like everything was uploaded into CODIS and everything was a no CODIS hit. And I just want the court to be clear that that's not the situation we find ourselves in.
Okay. Anything else?
No, Your Honor.
Mr. Hamilton, you may conclude.
In Carter 6, on paragraph 118, the courts held that the suppressed evidence would certainly have called into question Lieutenant Pierpont's testimony about Carter's unrecorded oral confession and the somewhat inconsistent written confession Lieutenant Pierpont dictated in his own words for Carter to sign. I think that's the crux of the issue. There are significant problems.
What paragraph is that?
That's paragraph 118. I apologize.
Okay, thank you.
There are significant issues with this confession, and those issues have never been fully and fairly litigated. And those issues that have not been considered in context of Mr. Carter's confession are material. And that is something that is just not up for debate. They're absolutely material. They undermine the credibility. And the state's argument that was not in its written motion, but they make today about Lieutenant Pierpont actually carrying out his threats, I don't think that is as convincing as the state hopes that it is. All it shows is that Lieutenant Pierpont was willing to follow through with his promise that if Mr. Carter signed this confession, Ms. Robertson would be released that day. He did, she was.
Your Honor, could I just say one last thing just on that small point? The arrest of the friend happened in Tennessee. Mr. Pierpont had no jurisdiction in Tennessee. He didn't have the power to do that. So I just want to make that clear as well.
But he was in a cooperative investigation. I mean, Tennessee had detained Mr. Carter. Mr. Pierpont went out, and Tennessee interrogated Mr. Carter.
Sure, absolutely.
So it's obviously a joint operation, correct?
I definitely concede that, but
And that point's well taken, but it begs the question of why did Pierpont then interrogate her for several hours? Which he did. She'd already been questioned, but he had his crack as well. And then after speaking with her, and she told him repeatedly, I didn't even know his name. I knew him as DC from Chicago, and I didn't know anything about him being a fugitive. And no evidence has come forward to dispute that pre-existing claim. That's always been her position. And nothing has ever changed that. But in spite of that, he interrogates her, in her words, aggressively. He threatens to charge her as a co-conspirator, even though she's told them, I know nothing about what's happening in Utah. I don't even know his name. I just allowed him to stay with me. And then, in furtherance of what Mr. Carter testified to about the promises made, those promises were fulfilled. So I don't know that evidence that shows that Pierpont followed through with his threats and his promises is as persuasive as they hope. And yet the Tovars were ultimately deported, but their testimony was that they viewed that as a threat. They viewed the threat of deportation and of taking their child away as a threat, and they cooperated in order to avoid those threats. But we're not here to argue that. What we're here for is because this has never been considered in light of the voluntariness of Mr. Carter's confession. All this evidence has never been considered under the totality of the circumstances. And this is a clear exception to issue preclusion. Under multiple cases or multiple jurisdictions, it's a clear exception. And it's a clear exception that's been employed in this court already. And it was employed in 1990. And so we're asking Your Honor to consider the rest of it. We went through the analysis, and I'm not.
I'll never stay.
Okay. And Mr. Carter wants to clarify the record that he actually never stayed with her. She was just a friend that was helping him, that he was staying elsewhere. I apologize, I lost my train of thought, but I think the ultimate issue that we're asking is that the state never contested the other factors that we analyzed exhaustively in our motion, and I'm not going to do that today. But I do think there is a clear exception to issue preclusion. First of all, the judgment was stricken, and the court under the PCRA has the authority to issue appropriate orders. And newly discovered evidence is a clear exception to issue preclusion. The totality of the circumstances of fundamental fairness is another clear exception. I think this falls under all of them. That there is material misconduct that led to Mr. Carter's conviction being overturned, and now we have evidence that suggests strongly that Mr. Carter was not the murderer. And I think that needs to be considered in light of the voluntariness of Mr. Carter's confession. His position has always been clear. He only confessed because of the threats against his friend. And we'll submit.
Thank you. The court will take the motion to suppress under advisement. Let's turn to the motion, the state's motion to have Mr. Carter submit buccal swabs for DNA analysis.
Your Honor, before we get to the argument of the motion, may I call Adam Yankee to the stand?
Yes. Mr. Yankee, thank you for your patience. If you'll take the witness stand to my right, climb the stairs. Once you arrive on the stand, please face the clerk, raise your right hand, take an oath to tell the truth.
Do you solemnly swear the testimony which you're about to give in this case now pending before the court be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please be seated.
Good morning, sir. Could you state and
Morning.
spell your name for us for the record, please?
Yes, it's Adam Yankee, last name Yankee.
Sir, could you tell us what your occupation is, please?
I'm a senior forensic scientist for the Utah Bureau of Forensic Services, also commonly known as the Utah State Crime Lab.
Could you tell us what your training, education, and experience is that qualifies you for that particular job, especially having to do with DNA?
Yes, so I have a bachelor's degree in biology. I started work at the crime lab, and that entails a series of a training period for every discipline that you perform in. So for myself, I perform both serology and DNA interpretation, and both of those disciplines had their own training modules and time frames that culminated in what we call competencies. Once we pass competencies, I have yearly proficiency testing for both of those disciplines. Serology, there's one proficiency test a year, and DNA, there are 2 proficiency tests a year.
And how many of those proficiency tests have you taken for DNA?
I got signed off in DNA interpretation, I believe, in 2017, so 2 a year since then.
Have you been assigned to work on the Douglas Carter case?
I have, yes.
And as part of that assignment, did you try to develop DNA profiles from evidence that was at the lab from the case?
Yes, I performed serology for this case. Those samples that I prepared in serology underwent DNA lab work, where profiles were developed that I then looked at for my DNA interpretation that resulted in 2 different DNA reports.
How many different unknown male DNA profiles did you find in the course of your work in the case?
So in my first DNA report, I was able to identify 3 distinct individual males that were labeled as unknown male number 1, unknown male number 2, and unknown male number 3.
Now, those 3 distinct individual males, those profiles, from what objects were they developed?
Unknown male number 1 came from, and I'm going to be possibly paraphrasing the description of some of these items without maybe referencing, but the blood that was found in the snow, that was a single source male profile that I then labeled as unknown male number 1. Unknown male number 2 came from a mixture that was found on a blood stain on the back door, the doorknob. And then unknown male number 3 was a profile from a mixture that was developed from side 1 of the pillow.
When you talk about this doorknob, is it a screen door or is it the actual door?
I do not know. I didn't collect the evidence from the crime scene.
Okay.
Can you explain to
Subsequently-
me what a mixture is?
Yeah. So in DNA interpretation, one of the first things that we do after the data is generated is we determine the number of contributors that we see in the DNA profile. So that ranges from single source, which means that the DNA represents a single individual. If it's a DNA mixture, then that means that the number of contributors is more than one individual. At the laboratory, I'm able to analyze mixtures up to four individuals.
Do you know how many contributors there were to the mixtures on the back door and the pillow?
Yes, for the back door, I believe that was a mixture of 2 individuals. And I did, at the time, for both of my DNA reports, I had the standard for the victim. And I did get an inclusionary statistic for her on the back door, which resulted in one remaining unknown individual from that 2-person mixture on the back door. For the pillow, that was a mixture of 4 individuals, and one of those individuals I got an inclusionary statistic for in my second report for Eva Olesen. And that profile happened to be one of the 2 profiles that I had initially in my first report submitted to CODIS. And so once the comparison, the inclusionary statistic was received for Eric, that second profile was removed from CODIS.
Thank you. Go ahead.
Thank you, Your Honor. Other than those 3 individual male profiles, were there any other profiles that you developed later on?
Yes. So I believe there are a total of 7 samples of the initial set of samples that I had. So in my second DNA report, I have 7 different samples that were all mixtures for continued comparisons, barring the first sample, which I believe was Q2.1.1, which was the blood found in the snow that had a CODIS entry that I submitted for that one. So there are 6 other samples after that one that have mixtures available for comparison, and that goes beyond the determined unknown male profiles that I've spoken of. There are also just mixtures that are general unknown individuals where I was unable to label a gender determination to those other unknowns in the mixture. For example, the pillow that we've been discussing, the swabs of pillow side 1, was a mixture of 4. Unknown male number 3 was a part of that mixture, and that was the unknown male that was consistent with Eva Olesen and then removed from CODIS. So the pillow has 3 remaining unknown individuals.
All right. We're throwing around the term CODIS a lot here. So just for the sake of the clarity of the record, could you tell us what CODIS is?
Yes, so CODIS is a national database of profiles that is used for investigative purposes. If in analysis of casework, a DNA profile is developed and it qualifies for CODIS entry, then I will submit a profile to CODIS for that entry. And then once it's in CODIS, it will search the database, and if there are any possible hits that are determined, those will be investigated, and a CODIS hit report would be issued to show that there's been a investigative lead.
How many profiles were uploaded into CODIS for the purposes of this case?
So in my first DNA report, I was able to upload 2 profiles into CODIS that qualified for CODIS entry.
All right, one of the profiles that was uploaded into CODIS was the blood in the snow outside the house, is that correct?
Correct.
And that was what you referred to was unknown male number 1?
Correct.
And that did not result in a CODIS hit, correct?
As far as I am aware, I work adjacent to CODIS. CODIS is maintained in its own secure system. So the way I relate to CODIS is in my casework, I can identify samples that I believe are
Right.
eligible and have them submitted. But after that, I don't necessarily know if there's been a CODIS hit or not a hit. Those are questions for someone from our CODIS department.
What was the second profile that was uploaded into CODIS?
The second profile that I entered in my first report was the first contributor profile from the swabs of pillow, side 1, that in my follow-up report, once I had the standard for Eva Olesen, that was consistent. And so I let the CODIS department know to pull that profile from the database.
All right, and in the time that it was in the CODIS database, that did not produce a hit, correct?
Not that I am aware of.
Meaning that Eva Olesen is not in CODIS, potentially.
I'm not aware, I'm not able to answer that question either.
Removing, and by the way, you referred to that pillow swab as unknown male number 3, is that correct?
So unknown male number 3 was one of 4 contributors to the swabs of pillow side 1, yes.
All right, so subtracting unknown male number 1 and subtracting unknown male number 3, how many unknown male profiles are left, individual unknown male profiles, that are susceptible to analysis should you get a DNA sample?
I have one other remaining unknown male, which I labeled as unknown male number 2. That's not to say that there isn't male DNA present in some of the other mixtures. It's just that I was not able to distinguish in the mixture and apply gender to those other remaining individuals. But there is an unknown male number 2 that remains from the mixture from the blood found on the back door.
And the other person in that 2-person mixture was the victim herself, is that correct?
I received an inclusionary statistic for the victim in that sample, yes.
So how many other samples that are ungendered, individual samples, which are susceptible to comparison, did you develop?
There were 2 rags that I also analyzed. I believe they were labeled, submitted as rags coming from a bathroom with possible human blood on them. I identified blood on them. Those 2 samples resulted in DNA mixtures of 3 individuals, and that was both rags that were tested. So there are 3-person mixtures on each of the rags, and the victim, I received inclusionary statistics for the victim on both of those rags. So there's 2 other individuals present on both of the rags. The swabs of the waistband of the pants that were submitted, that was a mixture of 4 individuals. Again, I received an inclusionary statistic for the victim on her own pants swab. So there are 3 remaining individuals on the swabs of the waistband. Off the top of my head, I'm trying to remember if I'm forgetting another sample. There were 2 samples actually taken from a knife that was submitted. There are swabs from the handle, and there were swabs taken from the hilt where the blade of the knife meets the handle, where there was potentially blood in the crevices around there that were swabbed. And the handle is a mixture of 2. I would need to reference my notes to remember further on my results for the blade, but the handle was a 2-person mixture with unknown individuals.
Both unknown, or was the victim's DNA?
I believe both are unknown for the handle. Without referencing my notes, I believe that the blood from the blade was consistent with the victim.
And we have no objection if he wants to refresh his recollection by reviewing his notes. I've got him right here if you need them.
And
Thank
that's
you.
totally fine. You want to?
Yep.
Thank you.
Just to make it official, would it refresh your recollection if we showed you a copy of your report?
Yes. I brought some. I brought my notes, if that's okay. Oh, sorry.
You did me.
It's on you.
I take full responsibility.
So the cuttings of the swabs of the red-brown substance where the blade fits into the knife handle, that was actually a single source DNA profile, and I received a very strong statistic for the victim being included in that. And I was correct in that the swabs of the knife handle was a 2-person mixture, and the victim received exclusionary statistics for the handle, meaning 2 unknown individuals are on the handle.
You don't have no further questions?
Do you have cross?
In your experience, is CODIS reliable?
CODIS, like I said, is an investigative tool. I'm sure there are varying levels of quality of DNA profiles that are being searched. The way that I interact with CODIS, I've mentioned while talking about this that if a profile qualifies for CODIS, so if a profile is not fully intact or it doesn't meet a certain threshold, that would essentially mean that CODIS would receive so many possible hits that it's not useful for an investigative lead. So I can't speak as far as whether I think CODIS is useful or not, other than it is useful, but I don't, pertaining to any given circumstance, I can't speak to.
Well, and I want to be clear, is it reliable in your experience?
I believe it's reliable as an investigative tool.
Okay.
Yes.
And I want to follow up on one thing you said about how not every sample can be sent to CODIS. What are the thresholds for submitting a profile for CODIS comparison?
So the thresholds when I'm determining if something is eligible to be entered is the evidence collection itself. Is it from a crime scene? Is it most likely related to the crime?
If I could pause you, and we've determined that the evidence that we was submitted, it meets that threshold,
I believe so, yes.
according to your belief. Okay,
Yes.
thank you.
To my knowledge, yes.
Fair.
Yeah. After that, I will run the DNA profile that I received from a sample. through what we call Popstar, and it will generate what's called the MME, which is a moderate match estimate. And if it meets a certain statistic there for the quality of the profile being entered, it will be eligible for what is called NDIS. It's the National CODIS database. Below that, there's another lower threshold where it qualifies for state-level CODIS, and then below that, samples are not eligible.
So is it fair to say that the purpose of these requirements for submission is for reliability?
For reliability, but also for CODIS to be useful as a investigative tool, like I previously mentioned. Someone in CODIS will have to look at every possible hit that comes back, and so a profile has to be robust enough to bring back a more narrow cone of possible hits to investigate. Does that answer your question?
And I think the state asked you this, but I wasn't quite sure the answer. You are aware of 3 profiles being submitted for CODIS comparison.
So I'm only aware of 2 profiles that were entered in my first DNA report. I entered a profile from the blood in the snow, which I believe is Q2.1.1,
Okay.
and I entered a profile from the pillow, the swabs of the pillow side 1, but that second CODIS profile that I submitted has since been pulled out of CODIS because it was consistent with Eric Olsen.
And what about the profile that was from the palm print on the door, the back door, the screen door?
So I don't know if it was a palm print, the information that I have, swabs from the back door. But that sample that I had said I determined had an unknown male number 2, that profile did not qualify for CODIS upload. So I was not able to submit that profile into CODIS.
And was it a STR profile or a YSTR profile?
My reports are STR reports.
Okay, were any YSTR profiles obtained?
I don't believe we have performed YSTR analysis on this case.
And do you know if Mr. Carter's profile is in CODIS, or is that where that separation comes in?
Again, there's that separation.
Understood. Thank you.
Your Honor, may I ask just one more question? Sir, even though a sample or a profile isn't susceptible to upload into CODIS, is it still enough information for you to do an analysis, a comparison analysis against a sample?
Yes, all of the samples that we've been talking about, there's still information there that I can make comparisons to. They just did not qualify for CODIS entry.
No further questions, Your Honor.
Can I just clarify then? You've mentioned unknown samples out of mixtures on the rags from the bathroom, the waistband of the pants, the knife. Were all of those not meeting CODIS threshold requirements?
Correct.
Maybe the easier question is, what samples did meet CODIS requirements?
So the samples that I entered into CODIS were the only ones that met those CODIS thresholds.
And
that was the single source unknown male number 1 profile that was developed from the blood in the snow, and initially contributor 1 of the 4-person mixture that was developed from the swabs of pillow side 1. And that profile has been rescinded with my second report.
Thank you. Any follow-up?
No, Your Honor.
No.
Very good. You may step down. Is Mr. Yankee free to go?
Yes, Your Honor.
No objection.
Thank you. Any additional witnesses?
No, Your Honor.
Go ahead.
Your Honor, it's the state's position that good cause and even probable cause exists to get the buccal swab from the defendant. We have a confession which has withstood scrutiny from the Supreme Court. I believe that leads to probable cause. I understand that there were 2 CODIS non-hits, but one of the CODIS non-hits was DNA that was actually belonging to someone within the victim's family that was uploaded into CODIS before it was eliminated. The other CODIS non-hit is blood in the snow outside of the crime scene. You've seen Mr. Yankee testify.
I was going to ask you, he said he doesn't know. Maybe you do. Was there a CODIS hit on that?
No, there was not a
unknown male
CODIS hit
sample?
on the, there was not a CODIS hit on the blood in the snow
Okay.
that was uploaded into CODIS. And I would like to point out, though, that that snow was outside the crime scene in the alley. You've also heard Mr. Yankee testify that there are multiple other profiles that can be tested. And when I first made this motion last year, it was denied because we didn't have anything to compare the defendant's DNA to.
Right.
Now, I believe with Mr. Yankee's testimony, there are profiles to be compared to the defendant's profile, and therefore I renew my motion.
Very good.
I think that this motion is premature, especially for us to be able to respond. We have a motion to compel information from the state crime lab that's pending. We have a discovery request for the state that's pending. The purpose of the subpoena and that discovery request is for us to obtain the raw data that our expert needs to be able to advise us. When we talk about DNA, I think that it's reasonable that we have someone to walk us through it, to make sure that we're not making mistakes, because I can already see mistakes that me, in my lawyer brain, has made in trying to interpret it, which is why we need an expert on board. We have an expert, and the first thing she requested was the raw data, which we immediately requested on July 17th, and then the subpoena on July 20th. In all candor, I think this is going to be something that we will ultimately agree to. We are not objecting. What I'm saying is we are not in a position to respond one way or another, because we need this additional information that we have requested, that apparently the state requested on August the 10th, but we don't have it yet. And we need that so that our expert can give us advice so that the results can be reliable. We've already heard the testimony that there are diminishing points of reliability based on the different profiles. I don't know how to interpret that. That's why we have an expert on board. And we would like her to be able to advise us so that we can come to an agreement on what should and should not be tested with the goal of reliability. So again, I do think this is something that we are ultimately going to stipulate to, but we need the information that we've subpoenaed and requested from the state that we do not have yet so that we can have a meaningful participation. Right now, the state's asking us to jump without looking. And on this type of a case, on an aggravated murder where they are seeking the death penalty, I think that request is completely unreasonable. We are asking that the court not consider this request today until we have our discovery responses in hand and our experts able to advise us. And we are happy to advise the court on when we are prepared to respond.
How long are you talking about?
That's a question for the state. As we have our expert on board, she's retained. I don't know how long it would take her to review the data once we get it. But right now, we're at the beginning. We've told them what the specific information that we've requested. The crime lab has objected to our subpoena. They say they need a court order. I believe that motion to compel is fully briefed. As soon as we get it, I would hope that it would be a few weeks before she can digest everything and get to it and let us know. But I mean, again, I don't want to appear that we're objecting. I want to be clear. We will probably, I anticipate us agreeing to the state's request. We're just caught flat-footed on this. We need more information so that our expert can advise us.
Thank you. From this state, this is your motion.
Your Honor, I believe that the court has ample information, that the standard is good cause. I believe we've made that standard, and I believe that the court has enough information to make a ruling. I will add, though, that we made a grandma request to the lab for pieces of information that defense requested. We got certain things. As soon as I got those things, we provided them to the defense. I believe there are some other things that the defense would like. But I'm not sure that, they were apparently not part of they were in my grandma request, but apparently not provided in the response to my grandma request. But I don't believe those things are required for the court to rule on this motion.
Thank you.
And one issue of concern that Mr. Carter has raised is that on the 10th of July, his blood was drawn at the jail, and they're trying to find out why. We've spoken with the jail, we've spoken with the state. No one is aware of why that happened. I think he wanted to express that concern to the court.
And Your Honor, I have no idea about that. Honestly, if I had a DNA sample, but that is not anything to do with me or my investigator or anything having to do with, this is the first time I've been made aware of it, so I don't even know how to react.
Thank you. It would seem like a call to the jail could determine that fairly quickly. I'd like to be in recess. Would you just reach out to the jail and see what that was about?
I'll see what I can do, Your Honor.
Thank you. We'll be in recess.
All rise.
Take it.
You got it. Just leave the whole thing right here.
Oh, I don't
Okay.
take it with you.
About multiple DNA profiles has made it clear that, well, that's really the hard part, right? Yeah. Yes. So on the news talking about how the DNA proves that he has to do that, when that's not what the DNA expert just said. Yeah. Let's call it. By the way, I think he just rocks, man. I just really enjoy that guy. He's autism squared. He's very good. Yeah, absolutely. He's taking on spectrum. Hello.
Just to make sure I heard you correctly when you announced your guys' names.
Sure. Erwin, E-R-W-I-N, Petilos, P-E-T-I-L-O-S.
Got it.
Stephen Jones, S-E-P-H-E-N-J-O-N-E-S.
With a PH. Yeah, thank you. We weren't talking too fast or cross-talking or anything, right?
No, you guys are good.
Okay,
You're doing great.
I practiced for like more than 20 years in states where we always had a reporter, so I got in the habit of not cross-talking and making sure.
Yeah, I
But
love
since
that.
I've been here, I'm out of the practice, so I just want to make sure that I'm not doing anything that's making your life
You're
harder.
still doing great.
Okay, good, all right. I think we're gonna make a motion to suppress, and I think we're doing DNA.
I think you know it was the DNA. It's a foregone conclusion. Why do you need the raw data? Like, we're not asking for your stipulation. We're asking the court to order.
I love the ball in this guy that he's always trying to leverage me to do things on a thing that he's been doing.
Right.
You know what I mean?
The motion to suppress is regardless. Because the judge is not going to be the one that makes that.
Sure,
ultimate
absolutely.
decision. Whoever loses is going to interlock it. And that's going to take, if it's picked up, it's going to take a year.
Are you and I gonna try this phase before we Poor Pete, we can't abandon Pete like that, man.
Okay. Does that happen a lot?
Well, if he's medically diagnosed with that, yeah.
Okay.
Yeah, I'm assuming so. That's
We may
I spoke to the nurse.
We may ask you to just tell the court. We got our answer, so
What?
we got our answer from the jail, so
Okay,
I think when everybody gets back,
okay.
we're
I
ready.
will let the judge know.
Did Richard talk to you? No. They said he has hypertension, and so his blood was drawn for a lipid panel.
Okay.
I don't know what that means, I'm not a doctor, but that's what they said.
Okay.
A lipid panel? Like what happens when you're 70 years old? 60?
He's been diagnosed with hypertension, so he had heart issues as a present.
Oh, okay.
Yeah. Yeah, I mean, he's been in the hospital several times. Said he was present for 4 years.
Okay. Yeah. Did you get my text message? He got his answer back. And he's had heart issues since he was in the prison. In the prison, he went to the hospital several times for hypertension.
Okay.
So it was a standard.
Thank you.
They had to get a lipid panel, and I told
Okay. Honestly, I feel like I needed a lipid panel because I've been eating a lot of omelets lately.
Probably you look a little omelette-y.
I love an omelet, but that leads to a lipid panel.
The bacon.
When this guy moves to Italy, he's going to need a lipid panel because he's going to be living on prosciutto. And that's right, I'm down with death by prosciutto.
We won't recognize you with that big smile on your face.
I don't necessarily have a problem with any of that.
Someone did say your name. This is going to sound like your name.
I probably said Bruins. It was UCLA. Go Bruins.
Oh, that was Boston.
What's that? Yeah, he said July 10th.
Are you ready, Mr. Hunt?
According to the
Yes, sorry.
Okay. Mr. Jones, are you ready?
Yes.
Yes.
You're good to go.
Audible, let the judge know.
Do you want to tell the court so it's not third hand?
Yeah. What's the double here, so yeah, double here, so.
Richard, do you want to just come up? Because you're going to have to say it into the microphone for the record anyway. doing that now.
You put me at the game.
No, yeah, we just use the phone. I just want to make sure we record it and get on the, on there. I was thinking about this giant heat wave we've been having this summer, and you were swimming through in the pool. You must be getting a lot of use out of it
My-
this summer, right?
My wife uses a lot.
What,
Swim small.
is it hot?
Well, I turned it down. Yeah. It's still 90. You know, if it's 100 degrees, 90 feels pretty good.
Right, it's just the swimming
Oh, yeah, she struggles with that a little bit.
in the spa.
But if you want to use it as a hot tub, ours is not a separated thing.
Mhm.
You have to turn it back up, you know, in the evenings. Up to 94, 95. It's nice
It's
to
not bad.
sit out under the stars.
In a summer like this, the cooling factor, I was waiting for it.
Well, it's hard to cool them down when the sun's hot.
Oh.
Do you guys have a cover for it so the sunlight doesn't hit it more?
No, well,
And does that even work?
yeah, there's a bifold hard cover that we purchased. Bifold back. But it's out
How long is it?
17 feet.
Do you have a dog or a cat?
No.
I was wondering if you could like teach your dog to swim into the current, like, get its exercise that way. I have a swimming dog now.
I've got kids.
Because I would totally do it to my dog.
The jacuzzi's hard enough to keep clean, but have a dog in there.
Sorry, I didn't let you
Yeah, could you imagine the dog there getting into the filters and the jets and stuff?
Well,
We just destroy the machine.
and they have the ashes.
Yeah.
Even with the cover on it, it's still got it.
Really? Where are you at?
Spanish. And it just will shoot a, you know, when you go out.
With the Eureka fire?
Yeah, I don't know which one it was. When that was really bad.
What is that? Raining ash on you guys.
You have to clean it. See, you have to clean the pool. But it doesn't take very long to do it. My wife wanted the pool. I wanted the hot tub.
This is the compromise.
It's a pretty good compromise, man.
Pretty expensive compromise.
Yeah, absolutely, man.
The pool would have been very expensive.
Yeah, 6 figures.
I know, it's crazy.
I don't have room for it anyway.
Any backyard's big enough if you really want to do it.
Honestly, considering all the contractor cases we have in the office, I feel like they'd never finish a pool.
That's true. Yeah, there it is. It's on the roll.
Listen, if anybody's promising to do your pool for less than $100,000, they're gonna rip you off.
Yes.
I figure I could do a whole halfway there. But they're like, that's not what the value is.
I just think when you start talking about stuff like that, you have a tendency to jump over dollars to say nickels and dimes.
Mhm.
You could work out for me, wouldn't you?
I'm with you on that.
Remember those basketball games before the shot clock, man? Someone would get like a
Oh, I-
10-point lead and they would just like throw it around the corners for like 3 hours.
Before the shot clock, and
Yeah, before the shot clock.
they would, like, I remember reading about BYU, like, they knocked out like one of the number one, because they got like a 3-point lead,
Right.
and they just held the ball
Right.
half court for like 20 minutes. And you're like, wow.
It's brutal. I love the shot clock and the 3-point line, are like the two greatest inventions in sport. If you're a basketball
Well,
guy.
The 3-point line is killing the sport now.
I gotta think, I'm gonna disagree slightly with you, because I think the true game of basketball is not really meant to be played above the rim.
Right.
And when you go back to the Bob Cousy days and all that stuff. It's a pick and roll.
Yeah.
And the three-point shot has completely changed the NBA.
Yeah, but that's over the last 10, 15 years.
Yeah.
John Stockton.
Building goals.
Yeah. Bill Russell.
Bill Russell.
Yeah, it's true. You hear so little about big guys in the paint now. Which is too bad, because I love that style of basketball. You know, like fighting for those 2 points with a 5 foot style. The game hasn't been the same since Michael Jordan, because he just changed it. Michael Jordan, because everybody wants to be Michael Jordan, everybody wants to look good.
I would argue Steph Curry's changed it immensely too.
Oh, listen, he did. Listen, that the guy was a freak. He can the shot. Yeah,
He crosses the half court.
it turned it into. But then everybody. Analytics is ruined everything. I kind of miss the '90s game for like
75 to 76. Yeah.
Oh yeah. Bill Lambier. Is that what we're calling it? Defense.
Absolute brutality.
But I like those are enjoyable games. To watch, yeah. I'm not sure they were enjoyable to play, but they were enjoyable to watch.
Chris Popovich and Sloan. Those coaches, that was all defense. In the NBA, it's defense. Now in the playoffs, they stop it.
Well, and it was the Phoenix Suns, the running down offense. In the '90s, that just, and then, what was it, D'Antoni took it to New York, and no defense, just score quickly on offense, don't play any defense.
Didn't he coach at Phoenix too?
Yeah.
Is that the
But I was a Phoenix Suns fan, and I hate the Lakers, man, because they were not as on every year in the playoffs. Right. I had a huge hatred for Michael Jordan. Because in the '93 series, I didn't like Magic Johnson.
Those were good games. Those Johnson, Bird, Celtics, Lakers.
Oh my gosh. You don't even know how good those were. Like, you don't even know how good the NBA, that was like the pinnacle of the NBA. It was like 1980 to 2000. Yeah. Those 20 years were really, really good.
I'm like, James, what are you doing, man?
You just go back and play. Nobody cares, man. Nobody cares. We like to watch you play basketball. I'm not looking for you for moral advice.
I just wanted you to get some rest. We're in the middle of a series here, man. Against a team with all you want. Yeah, that's true. That's true for us.
Well, there was those 8 years where only 2 teams won the championship, the Bulls and the Rockets.
Whatever happened to the team line?
Got old. Still around.
Does he do any color commentating for the NBA?
I don't think so.
Man, that guy was fast.
What?
That was so fast, that first dribble. But when he got it in the paint, like, he was so fast.
Akeem?
Yeah. Remember the Duke Bowl? Why was my guy doing more steroids?
I watched him where he set the record for the most 3-pointers in a game.
Yeah.
He didn't even jump, he would just do this. And I think
He's like throwing the
I think
ball
he had
down.
11 3-pointers that game. His son went and played at a high school in Kansas, Bishop engaged.
Did his son make it to the NBA?
Bowl. I think so. Not, he didn't do it again. Eat some food, bro. It's like Sean Bradley. Guy just never gained any weight.
Well, it didn't help that he went on his mission and didn't like lift or run.
They sent him to Australia with the express purpose, like, eat as much as you can. Get some weight. Well, that was back in the days where you didn't leave college. Now it's one and done. Everybody's one and done.
It wouldn't even be one and done if they didn't have a rule.
What's his name? AJ DePonce? One and done. Some play 1 year, teacher 1 year.
Anyway, maybe what, 7 million, 8 million every year?
Oh, DePonce.
I know with the NIL stuff, a lot of players are staying because they're thinking they
Yeah.
want to make more money in college than,
Yeah.
because if you're like a great college player, but you'll barely make the NBA,
Stay.
you stay and you make more money.
Like Fredette, if they would have had NIL money, Jimmer Fredette would have made a ton of money.
Absolutely.
Oh, that guy would have been,
Absolutely.
Actually, had he come into the league like 4 years later, he would have been, like after Steph Curry changed it,
Sure.
he would have been great.
Absolutely, I agree with that. That guy came to the flag.
Same thing. Just hit a three from half.
I think Jimmer's done all right.
I think
yeah,
he's.
I'm not worried about him. He's not going to be smoking meth and living in a tent under a bridge.
Well, he might, but it's not because he had to.
Sure, yeah. It'll be because he had too much money for meth. It's tough in here when you take a break and everyone wants to go.
Might have gotten a run.
Really silly.
Do you think we pick up the bail?
Yeah.
Or do you think he's gonna wanna? Can he do that without hearing what the DNA evidence is? Can he talk about the sufficiency of the evidence?
His intent on ruling the confession's not suppressed.
But how can he do it without making that ruling?
Yeah, I guess that's true. Well, he can because even if he doesn't make a ruling, as it is right now, the confession stands, right?
Yeah. Yeah.
So he doesn't literally have to make a ruling. He should.
They're gonna get appealed anyways,
Yeah.
so just rule. Just say, I'm finding X, Y, and Z. And if the court overrules me, the court overrules me.
Does the defense continue to say they're going to stipulate to the DNA?
I don't know.
If you're going to do the DNA, why don't you think about it?
I don't know. What is the law that you're gonna change? I mean, I'm not saying you shouldn't get it. Like, I get
Yeah.
it, but we're not asking for a stipulation, we're asking for an order
Yeah.
based on the available law.
I think he gets that he has enough
Mainly
information.
because they're out saying all of this stuff about DNA, which is obviously not true. Bless you.
Thank you. He knows we're ready, he's just back here reading.
Okay.
No, it's all good.
Or severely overstated.
We're still getting paid in the company.
Some more than others.
Yes,
Hey,
I'm
Mr.
sure.
I'm on retirement store. We're jealous of you, brother. You're about to retire.
Seriously?
Yeah, absolutely. Do we have veto power over that? 'Cause-
Yeah, I'll make it official here.
Can we override your retirement with a two-thirds vote in the office? Can we override your retirement with a two-thirds vote in the office? We can need a supermajority, which I think we can get.
I hope we can get me. I think 41 years is enough, isn't it?
Dude, that's more than that. Honestly, if I had the money, I'm retired today.
What? To retire in the way that you're accustomed to living.
Well,
He's probably got more money than he's invested.
I know,
than you and
I know.
together.
isn't that the assumption that you want to live a certain way?
Well, I mean, the reality is that just does digital felonies.
It's the easiest job
It's
I've
the
ever had.
easy, yeah.
It's really,
If it wasn't for the 2 death penalty cases that we were on, he'd have every Monday, Tuesday, Wednesday free.
I thought he did anyway.
He might. He might.
yeah, there's only a couple of cases that I really ramp up for. The rest of it's just super easy.
Yeah.
I don't make many G-Tugs.
Really?
No, that's not bad.
Hobble Creek?
Play a lot on Thursdays. I play a lot
Is that your,
Thursday afternoon.
How does your back hold up after all these years of golf with all that
Because
twisting?
I'm in top.
physical shape?
A lot of core work, man. A lot of core work.
That's through golfing.
Plus, you don't get into any car accidents like
Alex.
White Woods.
Oh, right.
I don't understand that situation. Why wouldn't he have a chauffeur?
If I were that rich, I would definitely have a Maybach and a driver. It would cost you a lot less than the DUI fines.
Oh,
Well, it would cost you a lot less than that, your loss of sponsors.
Well, remember when John Gruden, when he was coaching the Raiders, he got 2 DUIs while he was coaching the Raiders. You're a pretty wealthy man. Why don't you have a driver? You know?
he's coming back to TV.
Yeah, I guess so. They're paying those guys so much money. I mean, like that guy who just got fired, Romo, for his DUI.
Yeah.
His contract was $230 million, just for like flapping his gums back so far. That's a crazy amount of money. Isn't it?
Look at Troy Aikman.
Oh yeah.
Yeah.
What's Brady's contract with the?
Oh, he didn't
Oh,
talk. $300.
Was it?
yeah.
With Fox News or something?
Like he leaves it.
Like any of them.
But I feel like Romo's hourly wage is bigger because Romo just phones it in. Like Brady's actually like watching films and making real comments. And Romo's just like, it's good day for football. You know?
Well, I guess they took 2 jury trials from each judge and put them in stack.
Oh. It's good she didn't give up Adams. Or Mr. Wheelchair.
Problem is, we don't have there are no attorneys in Judge Stack yet. Because the Board of County Commissioners hasn't
Right, so he didn't have a
authorized
calendar.
that.
He
There's
just has
calendar,
trials.
there's just no attorneys.
He has a calendar? Who's covering the calendar?
I think he starts this week.
When's Judge Wright's last day?
I don't know where she is.
December.
Maybe she's on.
I think he's the week after on. It's just like he cares.
Yeah.
He's gonna be gone by the time the Supreme Court hears this case.
Stupid.
Just make a decision.
Exactly.
It's not many of the judges are not. Back in Kansas, which is very different, because back in
King
Kansas,
knows her,
the
right?
judge
He's
never
just-
could
he's got her
advise him.
reading.
It was awkward when he did. He'd be like, nope, I'm finding this.
My wife worked for the court. Way back in the Anyway,
Do you need to go down the stairs?
or whatever. He would make weird.
Yeah.
Judge Davis.
I think it's the standard now. They're all afraid of being overruled. Like, you got to on the bench.
To make the calls.
Decisions.
All rise.
Thank you. Please be seated. You can have Mr. Carter out again. We will go back on the record in the matter of State versus Douglas Carter. Mr. Carter is present with his counsel. The state's lawyers are here. Would you state your appearances again?
Erwin Patilos and Stephen Jones for the state, Your Honor. We lost Peter Wright.
Thank you.
Neil Hamilton for Mr. Carter.
Mr. Gale, join yet or no?
My understanding is he's at a sentencing in Castledale, and he's going to come up when it's done. It's another ag homicide down there that he was already scheduled for.
Are you prepared to proceed without him?
Yes.
Can the state proceed without Mr. Reitman?
Absolutely, Your Honor.
Very good. Before we move on to the bail hearing, let me just follow up. Do we know why Mr. Carter's blood was drawn at the jail?
Your Honor, Richard Hales is here. He's going to put on the record what he found out.
Very good.
Yeah,
Can I
you go
have
to the
you
podium.
take the witness stand and have you sworn,
Okay.
please?
Do you solemnly swear the testimony which you're about to give in this case now put before the court be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please be seated. Would you like to examine him or just have him tell me what he found out?
Let's have him state and spell his name for the record. Could you do that, please?
My name is Richard Hales. I'm a special agent for the Utah County Attorney's Office Bureau of Investigations.
And during the recess, were you able to reach the Utah County Jail and find out any information about the blood draw that happened to Mr. Carter on July 10th?
Yes.
What's the information that you received?
I contacted the medical unit at the jail, spoke to one of the staff there. They advised that Mr. Carter has a medical condition, hypertension, he's had for a long time. It was the blood test was part of the standard operating procedure to maintain for his health purposes while he's in custody of the jail.
Your Honor, I have nothing further.
Thank you. Do you have any questions? Thank you so much. I appreciate that. Anything further?
No, Your Honor.
Do you wish to be heard?
On the request for
Yeah,
the...
it sounds to me like the blood was drawn for medical purposes,
Yes.
not admitted into evidence in the case.
And we have a lot of questions about that, but not for this hearing. We're still trying to get his medical records, but we don't have anything else. I mean, our position is the same. This is just premature. We need more information so that we can be advised. And
Thank you. Is Officer Hales your case officer now?
Yes, Your Honor.
I'm so sorry. Could I have you just behind a microphone again? I don't want to assume. Just right there is fine. Can you just tell me, the blood that was drawn at the jail for medical purposes, has it been admitted into evidence in the criminal case for any purpose?
No, I'm not. I wasn't even aware of it until today.
Do you intend to use it in that way?
I have no intention of that.
Very good. Thank you. All right. Before we move on to the bail hearing, I have one question on the motion to suppress. I've just been thinking about how to proceed most efficiently, because if the court denies the motion to suppress based on the mandate rule, then Mr. Carter will file an interlocutory appeal, and that will go up to the court. It could just end right there. I may be right about that, and the district court would be sustained, but it's also in the discretion of that court to say, no, in light of this new evidence, we want to revisit this, and then it comes back down, and it would have to come back down because the trial record would be incomplete, it would seem, on the suppression question. And I'm wondering if we shouldn't take measures here that would complete the record on the suppression question. And then I rule on the motion to suppress, and, for example, the court could rule that the mandate rule prohibits decision. I haven't made that call yet, but the mandate rule prohibits the district court from reevaluating the admissibility of the confession without authorization from the Supreme Court. Then that goes up, and at least we have a complete suppression record where the court can make its call up there, rather than further delay. As I think about it, it seems to me that based on the PCRA case, the Supreme Court would have all the evidence related to Lieutenant Pierpont's conduct. What would be missing is what does the DNA analysis look like? If, assuming you believe that's relevant, we'd have to get that done. Is there anything else that would we have to have a further suppression hearing at all? Can you think of any reason why?
I don't, Your Honor. I think the record's pretty clear in the post-conviction documents. There's hundreds of pages of that, and much of it focuses on the interviews and Mr. Pierpont's conduct and what happened in Tennessee. I believe that record is complete for the purposes of analyzing the suppression without having to have further hearings here.
And I would note, we also have the record from the 1985 suppression hearing. So we have
Correct.
the testimony, in terms of the circumstances under which the confession was taken, we have the conflicted evidence of Mr. Carter and Lieutenant Pierpont. And so we have that. Is there anything else that we would need to complete the suppression record?
I don't believe so.
So just the DNA.
Yes.
Would there be any objection to staying ruling on the motion to suppress until the DNA analysis is complete?
I wouldn't have any objection to that, Your Honor, because all the motions that we have today are sort of interlinked. If there's DNA, then obviously there's substantial evidence and a capital case, and therefore the bail motion isn't well taken. If the confession is suppressed, there may not be substantial evidence, but if it's upheld, then there is substantial evidence. So I feel like all of these things, and also the presence of DNA would buttress the credibility of the confession. So all these things are interlinked, and I don't believe there's any harm in staying until there's some sort of resolution of the DNA, just because these issues all overlap onto each other.
Sadly, Mr. Yankee has left, but do we have an idea of how long that will take?
A lot of it depends on other things happening inside the county. Frankly, a lot of the analysis that happened in our case was delayed because another case came up that had a crime scene with all sorts of things that needed to be analyzed, and things that are things that take precedence can sometimes bump things to the back burner. And honestly, if no one gets killed in Springville, I feel like things will be faster, just because the last two things that bumped us off the priority list were things that happened in Springville.
Recent. Okay, thank you. Do you have any idea? I know you talked about your own expert analysis, and I don't know if that will be important to the suppression record.
And we don't either. We're looking forward to the day where we can answer it. And to be completely honest, I think if the DNA comparison should be dispositive of the entire case. If we have that side-by-side comparison to what everyone believes is the murderer's DNA,
And
Mr. Carter is excluded.
And
That
Carter
should,
is excluded. That's what we're missing.
that should be it.
Absolutely. If there's a lot riding on that test and these swabs. There's definitely arguments to be made that either way, these tests could be dispositive.
And so, to answer your court's question, we have no objection waiting. We do think that's important, which is why our response to the state's motion is we need to get it right.
The other issue, the reason I ask about timing, counsel, is I'm leaving the bench December 11th.
Boo.
So there's no judge in Utah who knows State versus Carter better than I do. I should rule on these issues.
Absolutely, Your Honor.
In my view. I sat as the judge in the PCRA case. So this is important that we move.
Your Honor, I believe that if the court rules in our favor on the DNA swabs and we get those quickly, I believe that we'll have some sort of analysis done by December 11th. And I agree that this court is uniquely qualified and uniquely positioned to rule on all of these issues.
And the other suggestion that we would have is the motion to compel is fully briefed. That can be ruled on.
Yeah.
And we can order the crime lab to immediately comply and give us what has been ordered subpoena.
What are the chances of the state stipulating to the defendant's motion to compel documents from the crime
I
lab?
think the chances of that are pretty good. I need to discuss that with people in my chain of command. But I don't, on a personal level, Your Honor, not speaking to my office, I never like to be in a position where I'm saying, no, you can't have that.
Yeah.
That's not a position I'm comfortable with. And so that's my position.
Thank you, counsel. To begin, I'd like to start with the motion for DNA evidence. Here, the state filed a motion and supporting affidavit together with a proposed order to compel Mr. Carter to submit buccal swabs for purposes of DNA testing. That's docket numbers 228 through 230. The defendant opposes that motion in docket 234. The state then filed an amended motion, affidavit, and proposed order at dockets 279, 280, and 281. Those filings are really in a reply to the opposition memorandum. The parties agree that this issue is now ready for decision. The court has taken testimony of Mr. Yankee from the Utah Bureau of Forensic Science, also known as the Crime Lab. The state's motion is made pursuant to Rule 16F of the Utah Rules of Criminal Procedure. That rule provides, subject to constitutional limitations and upon good cause shown, the trial court may order the defendant to permit the taking of samples of blood, hair, fingernail scrapings, and other bodily materials which can be obtained without unreasonable intrusion. Whenever the personal appearance of the accused is required for the foregoing purposes, reasonable notice of the time and place of such appearance shall be given to the accused and the accused counsel. Rule 16F is subject to constitutional limitations. The taking of buccal swabs from Mr. Carter's body would constitute a search under both the United States Constitution and the Utah Constitution, and therefore must be supported by a showing of probable cause. Here, the state has shown probable cause to believe that evidence of a crime will be found in the buccal swabs taken from Mr. Carter's person. Mr. Carter has a signed confession to having committed the charged offense. The state has also shown good cause for obtaining the buccal swabs from Mr. Carter. Previously, this court denied this motion without prejudice because no unidentified DNA profiles had been obtained yet. That is no longer true. Mr. Yankee testified that multiple unknown DNA profiles have been developed from a variety of evidence seized from the crime scene, including from the snow, the blood discovered in the snow in the alleyway, an unknown male profile number 2 from the mixture on the back door, unknown male profile number 3 from the mixture on side 1 of the pillow. Unidentified profiles on both rags. Retrieved from the bathroom of the home. 2 unknown profiles on each rag. 3 individual unknown profiles on the waistband of the victim's pants, and 2 unknown profiles from the handle of the knife. With these now unknown profiles, comparison between the defendant's DNA and these unknown profiles is supported by a showing of good cause. For these reasons, the court grants the state's amended motion to compel Mr. Carter to submit to buccal swabs taken from his body. The court does find that those can be obtained without unreasonable intrusion. I'm familiar, I think we are generally familiar with how those swabs are taken. They're just swabbed from the inside of a person's mouth, from the cheeks. Do you agree that that's how that's taken?
Yes.
Your Honor.
Very good. So they can be obtained without unreasonable intrusion. I will order that the state, this will require the personal appearance of Mr. Carter. For that purpose, I will order that the state give reasonable notice of the time and place of such appearance to both Mr. Carter and to his counsel who may be present at the time those are taken. I'll look to the state to prepare a written order consistent with my decision.
Take care of that, Your Honor. Thank you.
With that issue resolved, it seems to me that we can move expeditiously toward completion of the DNA testing.
Good.
I'm going to reserve ruling. The parties have agreed to stay ruling on the motion to suppress until the suppression record can be complete in the trial court. Is that correct, Mr. Hamilton,
Yes.
from the state?
Yes, Your Honor.
Very good. That moves us to the bail question.
And on the swabs, Mr. Carter just wants to know if we can have a date set by the end of the day, just
Yeah.
so that this isn't
Your
languishing.
Honor, I have Mr. Hales here. We can coordinate. That way we can give notice and have a date set. And then I'll write an order in conformity with whatever's decided and have that submitted to the courts later today or early tomorrow.
And frankly, if he's got a swab here, we've got a holding cell here, let's do this.
Okay, can we, that's great. Can you get me the order today?
Yes, I can do that,
Good.
Your
I
Honor.
will sign it today. It should have a date in it. We should be able to work that out before we leave today.
Okay.
Very good. All right. So that leaves us to the bail question. I guess the issue is the same. If the defendant wants me to reach the bail question today, I can. Or he can wait. It's up to him.
I think we would like the bail question to be reached today.
Very good. Do you have witnesses you intend to call?
We do.
Who are they?
All of them?
Yes.
We intend,
And are we going to have the exclusionary rule invoked here?
I don't think that's necessary, Your Honor, not
Okay.
for this proceeding.
Very good. Let me just make a list if I can. Okay.
our first witness will be Greg Rogers,
Greg Rogers,
and then we will call James Whitman,
James. Very good.
and then Melissa Anger, A-N-G-E-R. Tyler Anger,
Okay.
and I apologize, I'm desperately searching for her last name, Reina Hernandez.
And I've read Mr. Carter's affidavit, correct?
Yes.
Were there any other documentary exhibits?
I filed Exhibit 1, and that was the newspaper report from,
I did read that.
Okay.
And there was also a treatment letter or a residential letter.
yes, that's from Road to Reentry, and Ms. Hernandez also works with that, so she'll be testifying and giving an update to that.
You'll be admitting that. I can't remember what docket number that was.
That was admitted previously, I think several months ago, but yes.
What's it called again? It's the reentry.
Road to Reentry.
It's docket 242. Any objection to docket 242 being considered for purposes of the bail hearing?
No, Your Honor.
Very good. And from the state, will you be calling witnesses?
Your Honor, the family of the victim have a right to make statements, and two people will be making statements.
Who will be?
Oh, I'm sorry, Your Honor.
Teresa Olesen.
Who is it?
Teresa Olesen.
Okay.
Gary Olesen. And then 2 statements will be read.
From Peter Olesen and Eric Olesen.
Okay. Any other documentary evidence the state would be wanting me to consider?
No, Your Honor.
Beyond, I presume, the probable cause statement that would be considered at bail hearing?
Correct, Your Honor.
Okay. Very good. Thank you all, those of you who have attended today, for your patience. Let's begin with Greg Rogers. Good morning.
Morning.
Do you solemnly swear the testimony which you're about to give in this case now put in before the court be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you.
Go ahead.
Thank you. Good morning, Mr. Rogers. Would you state your name for the record, please?
Sure. Greg Rogers.
How do you spell that?
Gregrogers.
Very good.
Mr. Rogers, can you please state your training and experience in?
Sure. I'm a retired FBI agent. I spent 30 years with the Bureau working violent crimes. During my tenure with the FBI, I was assigned to the Navajo Reservation, and when you're assigned to work in what we call Indian Country Matters, you're sent to a crime scene investigation school, and you're certified as a crime scene expert because the vast majority of FBI agents in their careers don't work homicides and violent crimes like that, but when you're working in Indian Country, you're working homicides weekly.
How long did you work in that assignment?
About 3 years.
So-
And then after being assigned there full-time, I was transferred up to Salt Lake City and still worked cases on the Navajo Reservation and on the Ute Reservation. So I worked part-time those types of cases for the remainder of my career. So in total, I probably worked 3 years full-time on those matters, and then another 15 years part-time assisting agents that were in those assignments.
In addition to that experience, do you have training in use of force?
Yes.
And what is that training?
I was a member of the SWAT team for 20 years in 4 different FBI offices and have extensive training in use of force.
So I would move to certify Mr. Rogers as an expert in use of force.
Do you have any objection?
No, Your Honor.
Go ahead. He may testify within the scope of his expertise.
Thank you. Mr. Rogers, have you had a chance of reviewing discovery in this matter?
Yes.
Particularly about the crime scene and the stabbing that occurred?
Yes.
Are you, so you've seen what is believed to be the knife that was used to stab Ms. Olesen
Yes, I have.
and the evidence that was left behind at the crime scene?
Yes.
Do you have enough information to form an opinion onto that knife and any effect it might have had on Ms. Olesen's murderer?
Yes.
What is that opinion?
That opinion is when you would arrive at this crime scene, that knife is what's called a weapon of opportunity. That is just if I might be able to use the phrase, because it's the term we would use, the killer in this case didn't have what would commonly be referred to as a kit, which means he didn't come prepared with his own knife. It's also evidenced by the fact that he used extension cords and things like that in the house. So he didn't come, whoever the killer was, didn't come with a kit. And that knife doesn't have a strong grip. It's just also it's not a knife that would be used by someone who was trained to use knives in knife fighting or in some, that type of use of that type of a weapon. So because of the way that knife is manufactured and being no grip in it, no sort of, the handle is just slick. So because of the way the killer had to be thrusting that knife to make the deep impressions that he did in the victim's body, it's highly likely that he was holding it in a manner like this and coming down this way.
Do you want to make a record of what you just saw him do?
Yeah, and I could explain
It's all
that.
right. Go ahead.
And for the record, Mr. Rogers demonstrated a closed fist being held up at approximately a 45-degree angle and being brought down to a level parallel with the desk in front of him, so a downward stabbing motion.
Thank you.
Is that correct?
That's correct. Because if you were holding the knife in a different manner and thrusting forward, it'd be very difficult to get the amount of pressure you would need to make the cuts as deep as they were in the victim's body. So it's highly likely that he was coming down that way, as you just explained. That being the case, when the knife, the sweat on the killer's hands, plus the blood that would be coming from the victim would make that knife wet, has been indicated by where blood was found on the knife by the DNA expert. So it's highly likely that the killer's hand could have slipped off of the handle coming forward, which would have caused a cut in his hand also, because it's likely his hand would have slid down the knife blade.
So based on your training and experience, do you believe that there's a reasonable likelihood that some of the blood evidence collected belongs to the murderer?
Yes.
Okay. Thank you. No further questions.
Do you have cross?
No, Your Honor.
Thank you. You may step down. Next, is it James Whitman?
Yes.
Good morning, Mr. Whitman. If you would be sworn, please.
Do solemnly swear the testimony which you're about to give in this case, now and before the court, be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Could you please state and spell your name for the record?
James Whitman, James-Whitman.
And what is your occupation?
So I'm a mitigation specialist.
What does that mean?
So I work on, in a capital case, a mitigation specialist is one side of the investigation. There's the side that Mr. Cordes does, which I call the CSI case, or the crime scene case. The mitigation specialist develops a life history, family history story of the person, aside from just the criminal side of what he's been accused of, to try to educate potentially the jury on the person's life where they grew up, who their friends were, who their family were, what their situation was as far as growing up, and any kind of mental health issues that may occur with the family as well as the defendant, to try to, again, try to educate the jury, give them a whole picture of the person in a story that doesn't depend on what they've been accused of.
Thank you. So in Mr. Carter's case, you've interviewed and you're familiar with his family members?
Yes.
Okay. Can you please tell us where his family members live?
He has several family members that live in Florida, in the state of Florida, and he also has 2 sisters that live in the Chicago area, and he's also got a biological son who lives here in Utah.
In speaking with the family members, I want to focus on 1985, when Doug was apprehended in Tennessee. In speaking with them, do you have an understanding of the family's belief or why they believe that Mr. Carter ended up in Tennessee?
So Mr. Carter was involved in an altercation with a female, I don't remember her name, where she accused him of assaulting her. I think it was with a 2x4. They got in a verbal argument, and she reported that to the police. And Mr. Carter's family that were here, they assumed that he left the area because he was afraid he was going to be charged with that assault.
Okay, thank you. No further questions.
Any questions from the state?
No, Your Honor.
Mr. Whitman, thank you. You may step down.
Your Honor, the court previously held her testimony from Jency Anderson. We didn't intend on calling her. That testimony would only be limited to establishing that Mr. Carter's DNA is in CODIS. So she's here if you want to take evidence on that again, or if
You know,
we're
I
okay.
don't believe we need to take evidence on that again. I believe we all know that Mr. Carter's DNA was taken in 1996 and placed into CODIS.
Very good. Will you just make a record of her name and proffer what her testimony would be?
Yes, her name is Jency, Jensie, Anderson, Anderson. Much of her testimony was already covered by Mr. Yankee. The only additional information she would have added is that she personally verified that Mr. Carter's DNA profile was taken in 1995 and uploaded into the CODIS database. So just confirmation that Mr. Carter's DNA is in the CODIS database.
And has been since 95?
1995, correct.
I actually believe it was 96, Your Honor. They tried to take it in 95 and he refused it. They actually were able to get it done in 96, and that's when it was uploaded. But it doesn't really matter either way.
Okay. Sometime in either 1995 or 1996.
Long time either way, Your Honor.
It's in, and it's been in for longer than a year.
Very good.
Our next witness would be
Let
Melissa.
me just.
Sorry.
Is Ms. Anderson here? Okay. Thank you. Do you agree that that's what your testimony would be?
Yes, sir.
Very good. Thank you. Can she go?
If she wants to.
Yeah. You can stay if you like, but you're free to go. All right. Next.
We call Melissa Anger.
Thank you. Ms. Anger, if you'll take the witness stand as well. Once you arrive there, please raise your right hand, take an oath to tell the truth.
Do you solemnly swear the testimony which you're about to give in this case now pending before the court be the truth, the whole truth, and nothing but the truth, so help you God?
Thank you. Please be seated there. Can I ask you to move toward that microphone? You seem soft-spoken, so if you could
I'm
speak.
not.
Yeah, she's not.
Don't you worry.
Maybe it's my hearing then. If you could just speak loudly enough, you can hear your own voice amplified. Go ahead.
Would you please state and spell your name for the record?
Melissa Anger, Melissa Anger.
How are you?
I'm good.
How are you related to Doug Carter?
He's my father-in-law.
When did you learn this?
In 2010,
How did you learn this?
Tyler and I started dating, and he told me who his birth parents were.
When was the first time you reached out to Mr. Carter?
That was after the November 18th hearing. Tyler and I were driving home, and we called you on the phone.
What took so long to reach out?
I didn't know how to get in contact with him. Otherwise, I would have done it sooner.
What's your current relationship with Doug?
It's growing. We talk almost every day, sometimes 2 to 3 times a day. He calls at night. It is a growing relationship.
Do you have children?
I do. I have 3 children.
Does Doug have a relationship with them?
They know of Doug. They know everything about Doug. Doug knows of them. They are in and out of the room when we are on the phone with Doug. The phone calls are usually on speakerphone. And they've never been video calls. They've only been a normal phone call.
When was the first time you laid eyes on Doug?
It was going to be September 2nd. That was the Tuesday after Labor Day, but Your Honor was sick, so we were rescheduled for September 23rd. And so I was here for that hearing. That was the first time that I saw him in person walk into the courtroom.
But last year,
Last year,
2025.
yes.
Very good, go ahead.
Have you ever seen Doug in person outside of court?
No.
You ever had a meeting with him at the jail behind glass?
No, ultimately, when Tyler and I had been dating for a few years, I had started the process of trying to go see him at the prison. But this has been a very hard thing for Tyler to deal with, and I wanted to be respectful of him. And so I never followed through with visiting Doug at the prison.
If Doug were released, what would that relationship with him look like? Do you think it would change?
I think Doug would get tired of me trying to be around him all the time. He would have daily involvement with me and my children and Tyler and our family as a whole. And not just us, but our extended family, friends and family.
Do you anticipate that Doug would live with you if he was released?
If needed, I think that would be overwhelming for Doug. We have 2 corgis. He can attest to 1 barks all the time. And kids, I get overstimulated in the house, so I imagine it would be very difficult at times for him, but if it was absolutely necessary, yes, we would consider that.
What plans have you looked into as far as housing for Doug if he was released?
So originally, I started looking into apartment complexes. I looked at between 4 or 5 different apartment complexes within a 5-mile radius because I would like him to be close to us. All of those apartments require a background check and a credit check. And we asked, what would happen if there was 0 credit, and that's not an option, and more money can be put down. But if there is anything on a background check, it would be an immediate denial. Some of these apartments we toured to see what they would look like. And again, after a background check was mentioned, then Tyler and I came to the realization that most likely wasn't an option. So then I looked into Airbnbs. The majority of the Airbnbs that are near our home are a casita or a basement apartment, which I know that most people wouldn't feel comfortable with that. So I didn't look into that further. I started to look into re-entry programs. There are federal programs available, but he does not qualify for those. There's 2, by the way, 1 for men and 1 for women, and they're downtown. That I don't think would be feasible for me to take him where he needs to go, to have daily involvement with him and him with our family. There are some re-entry programs that are not federal programs, but those all revolve around substance abuse, which is not a factor here. And One, we got an acceptance letter from that said they would be willing to take him in, but he would, as part of that program, would be required to do hours of substance abuse counseling as part of their program, and so I didn't feel that that would be a good fit. So then I looked into extended stay hotels, and there were 3 to 4, but ultimately landed on one that's 4.5 miles from our house. And spoke with them. You can do a 3-month stay that can easily be renewed after 3 months. He would have a 2-burner cooktop stove, a full-size refrigerator. We can worry about laundry and all of that at our house, but ultimately he would be set up with a comfortable place to spend part of his days and nights.
And the planning, and is Mr. Carter on board with this planning to your best understanding?
I think so.
The planning seems to focus on Doug being within a close proximity to you.
Absolutely. I feel more comfortable with that.
Can you expound on that? Like, why do you want him close?
The world has changed in the last 41 years, and I can only imagine the pressure, the confusion, the frustration that will come of learning how to live in today's world. And he will need help, and I am available to help him. So I want to do that. Give him transportation, take him to where he needs to go, but then also to include him in any activity that he's willing to take part of with our family.
And you said you're available to help. Can you expound on that? Like, what is your availability? Do you work out of the house, or are you at home?
Yeah, what I do, I work from home. I homeschool my youngest child, so we're home all day, every day. I take my 12-year-old to school and we pick her up, but that's 20 minutes each time. And then my oldest is graduated; he's 18, so I am home all the time and could make myself available for whatever I needed to in order to help Doug.
Are you willing to do that?
1,000%, yes.
Why? Sorry.
He didn't do this. I'm sorry, but he didn't. And he is a human being. And his life was taken from him based on some very unfortunate things. And why wouldn't I? He's a human being. I'm a human being. We care for Doug immensely. Even in the short time of getting to know him, we care for him a lot. And I want to help him.
Do you have any concerns for yours or your family's safety with Doug being involved in your life?
No.
Has Doug ever made eye contact with you when you've been in court?
It took some convincing. In the beginning, he would come into the courtroom and just look straight ahead. And we had asked him over the phone why he didn't look over. And he said that maybe Your Honor has asked him not to do that. And so out of respect for his courtroom, he never did. But then we made the suggestion, we'll just cough and look over in our direction. It will be okay. But that struck me as part of his character, that he, now knowing that he had family supporting him from day one, as soon as these hearings began, he had more respect for the courtroom than his own curiosity getting the better of him.
In your many conversations with Doug, do you feel that he's open with you in his conversations?
Yes.
Has he ever expressed a desire to hurt, either physically or psychologically, anyone associated with this case?
Never.
Has he ever expressed a desire to hurt, either physically or psychologically, anyone from the Olesen family?
Never.
Doug expressed a desire to get revenge against anyone involved with this case, physically or psychologically?
Absolutely not.
What's your understanding of what Doug's goals are?
Doug wants to enjoy whatever he has of the rest of his life as a free man.
Has Doug ever expressed a desire to run or flee the court?
No, he has said that he would like to visit his mother's grave and his sister's grave and his brother's grave. But no, it has not ever been a suggestion of, I need to get out of here, I need to flee, ever. He has just said that he has wanted to visit their grave sites.
Has Doug expressed a desire to see this case through to the end?
Yes,
Do you have an understanding of where he wants to live the rest of his life?
he has mentioned living with his sister, and unfortunately he has struggled to be in contact with his sister in the last month or so. He has also said just a simple home of his own, maybe in Colorado, in the middle of nowhere, away from people.
Does he have concerns with living in Provo?
Yes, and understandably so. I don't blame him for feeling that way.
Thank you, Melissa.
Thank you.
Pros.
Just a few questions, Judge.
Yeah.
Would any of your answers change if his DNA came back that he was at that house?
No.
Okay. Those are all the questions I had.
Thank you. Ms. Anger, you may step down.
Thank you.
Next is Tyler Anger.
Yes.
Good morning. If you would raise your right hand, go ahead.
Do you solemnly swear the testimony which you're about to give in this case now coming before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please be seated. You may proceed.
Thank you. Would you please state and spell your name for the record?
My name is Tyler Anger, Tyler Anger.
And what is your relationship with Mr. Carter?
Mr. Carter is my biological father.
Why do you say biological?
I was born and I was adopted at 5 days old. I found out from my birth mother who Mr. Carter was, and that's kind of how we got to that.
How old were you when you met your birth mother?
I was 18 years old.
And who is your birth mother?
Her name is, currently it is Ann Davis Lopez.
And how old were you when you found out that Mr. Carter was your father?
It was about 2009, December of 2009, so 26, 27.
When was the first time you contacted Mr. Carter?
Sometime about then, in the 2009, 2010 timeframe.
And how long did those communications occur?
A couple months, 2-3 months.
Why did they stop?
It was a lot for me to hear. It was a lot to hear that, to find out who he was, what he was accused of, and it messed me up pretty good. And so we communicated for a couple months, and I got a little wild. I ended up in the bar almost every night, trying to cope with it. And it got to a point where everything in life was too much, and so I left. I left Salt Lake County and I moved to Logan to attend Utah State for a year.
And where did you meet Melissa? You're under oath.
She would cut my hair from time to time, and then we would see each other on Taco Tuesdays.
This is up in Logan?
No, Your Honor, this is in Salt Lake County.
I see. Go ahead.
Thank you. When did you resume contact with Mr. Carter?
Last fall of 25. I couldn't tell you the exact date, but it was fall of 25.
What made you decide to resume contact?
A questioning of, I guess, kind of selfishly, me, trying to figure out about me, but also trying to figure out more about Doug. When we had originally talked, we couldn't talk over cell phones. He didn't know kind of what a cell phone was at the time, so we would have to talk on a landline, and we talked 3 or 4 times maybe. He sent me some stuff, sent me some letters. Yeah.
How often have you communicated since then?
We talk a lot, almost every day.
What's your relationship overall with him today?
Doug's my pal. He's my buddy. I'm trying to learn more about Doug. I'm sure Doug's trying to learn more about me. This has been it's been kind of an interesting. I don't know anybody else who's kind of gone through what I'm going through in that aspect, and so I don't know if anybody's ever tried to talk to somebody in the jail, but if you're on Securus, good luck. You get about every third word that he says. So in that aspect, it is very, very frustrating.
And what is Securus?
Securus is the jail's way to communicate, whether through text message, through phone calls. We tried a video call one time and had about 2 minutes before it shut off.
Have you ever had a face-to-face conversation with Doug?
This is about as close as I've ever been to Doug, right here, when I just walked past him.
So, have you ever shaken his hand?
No, sir.
What's the plan for if Doug is released? Will he be involved in your life?
I would hope he would want to be. I would like to be involved in his.
In any of your conversations with Doug, has he ever expressed a desire to physically or psychologically harm anyone? Associated with the case, not associated with the case, anyone?
No.
Has Doug expressed to you his goals regarding this case?
He would like to see it all the way through.
Has he ever expressed a desire to flee?
No. Where would he go? He doesn't have a driver's license. He doesn't have a car. He doesn't have any money. Where would he go?
Has he expressed a desire to you to clear his name?
Yes.
Thank you.
From the state, any cross?
No, Your Honor.
Thank you, Mr. Anger. You may step down. Reina Hernandez.
Yes, Your Honor. Thank you.
Please for the testimony which you're about to give in this case now pending before the court. Be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you. Would you scoot forward, speak loudly enough you can hear your own voice amplified. Go ahead.
Thank you. Would you please state and spell your name for the record?
Yes, Reina Hernandez, REYNA, HERNANDEZ.
And Reina, where do you work?
I work at Road to Reentry.
What is Road to Reentry?
It's a nonprofit organization that works to help freed and exonerated people or wrongfully convicted people after they've come home.
How did you get that job?
It started with a volunteer experience. I was a reentry specialist looking for, I was working on my PhD and looking for a direct experience in addition to my academic experience. And so that was an opportunity where they were building up the organization, and I came upon almost founding of the organization to work there and help people directly in that way.
And you kind of answered my next question, but what's your education?
Yes, so I have a bachelor's in criminology, a master's in social sciences, another master's in sociology, and a PhD in sociology.
Is that all?
That's all.
Prior to Road to Reentry, what was your work experience?
I was a student for a long time. I worked in childcare. I also worked in research, doing public health research. And through my career as an academic since 2017, I was studying wrongful conviction and reentry.
Are there a lot of people that do your job?
No, it's very niche.
How many exonerees have you worked with?
I worked with directly and indirectly about 150, and it might be over that.
Okay. Can you talk about what your job with Road to Reentry entails?
Yes, I work either before release or after release to create a reentry plan for every individualized person who comes to us needing help. We help with everything from employment, immediate reentry needs, health, education, and housing, and assist freed and exonerated people through that process, as well as providing programs and services that are tailored to the needs that they have upon coming home, including legal obligations. We have a court support program, and justice circles to build community with our community and alongside our community, and provide long-term and short-term case management as needed.
Can you tell us why is a reentry plan necessary for these people, this group?
Yeah, I think there are a lot of hardships that come and challenges that come with being home after being incarcerated for so long. There's a long-term institutionalization that causes a lot of trauma, stress, anxiety, depression after incarceration and through incarceration, and so those conditions aggravate. We consider both in research and practice that reentry is a big event in someone's life that causes a lot of stress and hardship and challenges. And so creating a system of support is important, and therefore creating a reentry plan provides that support and structure to build that network of people, community, organizations that are there to fill gaps that sometimes the government can't fill, sometimes communities on the ground can't fill, aside from those people.
Why is that important that we build this system up around them?
I think because of the aggravating factors of institutionalization, especially for someone like Mr. Carter, who's been incarcerated for so long, I think providing that support is crucial to build pro-social relationships and also factors that mitigate the challenges that do come with coming home, which is often a shocking experience that aggravates the anxiety, depression, trauma that does come with incarceration.
Where are you based out of?
Chicago.
How would that work with someone re-entering in Utah with you being based in Chicago?
We actually work a lot with people who are out of state, and so the support that we provide comes with creating that reentry plan, being in touch often with family members and the client as well. Getting to know the client, like I said, short-term and long-term case management that we provide comes with communicating with the support network of the client as well, and also creating that support network for the client. And so that comes with, if it's an out-of-state client, a lot of phone calls. They'll probably get tired of us bothering them, or being there often and checking in often. But they'll get to know us really well in a way that provides that comfort level and feeling of support, that they do feel they have someone to call that understands their situation, that has worked with people who have that expertise in that area to support them in a way that's tailored for their needs.
What are some common resources that people re-entering society after lengthy periods of incarceration need?
That spans from social, material, emotional support. That's, like I mentioned, us being a check-in source, a person that is there emotionally and socially. We often provide material supports that either are financial or material as in clothing support, resource allocation and also care coordination is one of the main things that we do. And that means for an out-of-state client, providing expertise in the area as to where they live. So we become kind of experts in the community that they live in so that we can be familiar and coordinate care properly and provide the network and resources that are accessible to them.
Are the resources that exonerees need, are they available in Utah?
Yes, absolutely.
Okay. Individuals in Mr. Carter's situation, people that are looking at potential exonerees whose convictions have been overturned after serving a lengthy state sentence. In your experience, do they traditionally face different challenges than those who are just re-entering society after having served their sentence?
Yes, I think that comes with the specialized expertise that we bring, which is, there's a lot of varying legal obligations that a lot of people who are released don't face. For example, petitioning for exoneration and other legal avenues that aren't familiar to the formerly incarcerated population more broadly. And also increased susceptibility to mental, physical, and emotional conditions that I mentioned before. Anxiety, depression, post-traumatic stress disorder is a common thing. Exonerees are often described as similar to war veterans and refugees. So those conditions that are similar to that population or those populations are common among exonerees and free and exonerated people broadly.
You've worked with exonerees that have not been on death row.
Correct.
And you've worked with exonerees who have been on death row.
Not exonerees who've been on death row, but I have worked with exonerees who have had life sentences, which is very similar to conditions for people who are on death row and who have experienced death row as well.
So for those people in that situation, that they don't believe they're ever going to be released,
Mm-hmm.
do they face different hurdles and challenges than other exonerees did who had a light at the end of the tunnel?
Yes, and I've also studied death row exonerees. There's been a lot of studies on specifically that population. And so those, like I mentioned before, those challenges are aggravated because of the intense deprivation, sensory deprivation and deprivation to the world that they experience, 23/7, sometimes 24/7. And so that...
Can you expand on that a little bit? Like what is your understanding of what life is like on death row?
Absolutely no contact with people, the outside world for the most part, and no sensory experiences really. You're locked pretty much 23 hours a day inside with no communication or anything in connection to the outside world, and so that makes it much more challenging to navigate the outside world once that does happen, if that does happen, and yeah.
Does your reentry plan address these unique challenges?
Absolutely.
In your experience, either be a personal experience or through your training and education, are people in Doug's situation, specifically people who've served lengthy periods of incarceration, have had their convictions overturned, and are working on exoneration, are they a flight risk?
No. I think that for the reasons that others have mentioned, having deprivation from the world as well makes it more challenging to get back on someone's feet, and so reliance on support systems that are existent is essential and crucial for pro-social relationships and the transition to be successful. And so I lost my train of thought, but
It's never happened to me. Do they know how to function in society?
No.
I think the question was, is this population a flight risk? That's what
correct.
Was there anything more you wanted me to know about that?
Thank you. No, so we do have also recommendations for that in terms of gaps for support when it comes to flight risk. But as other people mentioned, Mr. Carter doesn't have a license. It's very unlikely for people to be a flight risk when they don't have support systems or people that they know outside of their immediate community as to where they're being released. And I don't believe that he is a flight risk for those reasons.
Would Mr. Carter face financial difficulties if he were released?
Yes, but he does have support from his family that they have committed to providing financial support and also organizational support that will be there from Road to Reentry. And also we build a lot of partnerships with other organizations on the ground that also provide financial supports and other kinds of material and emotional supports that will be available for Mr. Carter.
What would happen to that financial support if Mr. Carter were to flee and to not show up to court?
Yeah, that financial support would not be available.
In your experience and in your training and education, what is the attitude of exonerees or people entering society who've served lengthy sentences? Are they angry?
I think they have a sense of injustice, understandably, but not angry. I think that really their focus is to see their case through and clear their name and move on with their lives as much as they can. And I think providing these supports is the way to do that.
Have you ever worked with someone who has, after being released, attempted to harm either physically or psychologically the family of a victim in their case?
No.
Have you ever worked with someone who, after their release, has attempted to harm either physically or psychologically police or anyone associated with the prosecution?
No.
In your experience, what should we expect from someone in Doug's situation to focus on after their release?
Moving on and clearing their name. And I think one of the concerns also for many exonerees, from my experience, has been the fact that victims do feel an unresolved. And so I think there's more focus on that and the fact that the actual perpetrator is out there and there's no resolve for anyone in that case. And so I think moving on and being in a mode where they're focused on that is priority.
Have you reviewed a plan to have an ankle monitor installed on Doug if he's released?
Yes.
In your experience, would that be sufficient to ensure that Mr. Carter would return to court?
Yes. It provides layers of security and assurance that he will return to court when needed.
Thank you.
Thank you.
Cross.
No, Your Honor.
Thank you. You may step down.
Thank you.
Do you rest?
Yes, we do.
Very good. From the state?
Your Honor, one of the victims is on WebEx, Ian. I'm wondering if we could make him a panelist so that he could read a statement.
Who is it?
Ian?
He wasn't on your list, sorry.
Judge, I believe he's reading somebody's statement.
Oh,
I'm sorry, Your Honor. Yes, Ian's reading someone else's statement.
Can you see him on there?
I saw his name.
Is it the I or? Oh, wait.
There it is, Ian Olsen.
And he's reading Peter Olesen's statement, Judge.
very good. Mr. Ian Olesen, are you there?
It looks like he's muted, judging from the icon, Your Honor.
Yeah.
All right, good afternoon, Your Honor. Are you able to?
Are you there, Mr. Ian Olesen?
Yes, Your Honor.
Very good. Can you turn on your camera, please?
Are you able to see me, Your Honor?
I am now. Let me just, my understanding is you intend to read the statement of someone else today, is that right?
Yes, Your Honor, I intend to read the statement from my father, Peter Olesen, as well as my own individual statement, Your Honor.
Judge, I didn't know that he was going to, and we would like to add him to the list if possible, Judge.
Okay. Thank you. Can I just have you raise your right hand, take an oath to tell the truth? Do you solemnly swear that the evidence you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, and that you will neither communicate with nor receive any communications from another person during your remote testimony, unless authorized by the court, so help you God?
Yes, Your Honor.
Very good, thank you. Mr. Olesen, how do you spell your name?
First name is Ian, I-A-N. Last name is Olesen, O-L-E-S-E-N.
Very good. Could we begin with your own statement?
Yes, Your Honor.
Go ahead.
So, Your Honor, my name is Ian Olesen. I'm the eldest grandchild of Eva Olesen. I respectfully submit the statement on behalf of myself and the Olesen family in strong opposition to the request of the release of Douglas Carter on bail. When my grandmother was murdered, I was only 12 years old. She was 57 years old. Her murder forever changed the course of my life and the lives of every member of our family. Today, I'm 53 years old, and more than 40 years later, the pain and loss remain. I'm deeply concerned about the risk that Douglas Carter may fail to return to the court if released. Mr. Carter has spent approximately 41 years serving a sentence for this crime. If released, he would face the possibility of returning to prison for the remainder of his life should legal proceedings continue to uphold his conviction. That reality creates a significant incentive to avoid future court appearances and further incarceration. The court should carefully consider whether any conditions of release can truly eliminate that risk. The Olesen family has already waited more than 40 years for justice. We should not be forced to face the possibility that justice could once again be delayed or undermined. I'm also concerned about the safety of my family, myself, and our community should Douglas Carter be released. For more than 41 years, our family has lived with the knowledge of what happened to Eva Olesen. The possibility of Mr. Carter's release would create a significant fear and anxiety for many members of my family. While decades have passed since this crime occurred, the emotional impact remains profound, and the prospect of his release would force many of us to relive the trauma we have carried for almost all of our lives. Our concern extends beyond emotional distress. The court must consider whether releasing a person previously convicted of violent homicide after more than 4 decades of incarceration presents a risk that cannot be fully predicted or controlled. Our family would live with the uncertainty of not knowing what actions he might take if released and whether the safety of our family members and the broader community could be adequately protected. Additionally, after spending approximately 41 years in prison, significant questions naturally arise regarding an individual's ability to successfully adjust to life outside of incarceration. Any person returning to society after such a lengthy period faces substantial challenges. I ask the court to carefully consider the physical, emotional, behavioral, or mental health factors that could affect public safety, compliance with court orders, or the ability to successfully reintegrate into the community. Regardless of those considerations, the reality for my family is that his release would create fear, uncertainty, and emotional stress that we have worked for decades to manage. We would once again be forced to live with the concerns for our safety and the safety of those we love. My grandmother never had the opportunity to grow old, enjoy retirement, watch her grandchildren grow up, or meet future generations of her family. Those years were stolen from her forever. While Douglas Carter has had more than 41 years to live beyond the day my grandmother's life was taken, Eva Olesen was denied a single additional day. Justice requires that her loss and the loss suffered by her family not be forgotten. Nothing can bring Eva Olesen back. Nothing can restore the years, the memories, and opportunities that were stolen from her and those that have loved her. I have lived more than 40 years, with the consequence of this crime, carrying the loss of my grandmother from childhood to adulthood. For 40 years, the Olesen family has lived with a life sentence of our own. Unlike Mr. Carter's sentence, ours came without the possibility of parole, without appeals, without the possibility of bail or release. We continue to carry the grief, the absence, the consequence of Eva Olesen's murder each and every day. For those reasons, including the last impact of our family, the risk that Mr. Carter may not return to court, the safety concerns his release would create for our family and the community, and the fact that his confession has been upheld repeatedly in the Utah Supreme Court at least 2 separate occasions, I respectfully ask the court to deny any request for bail. After more than 40 years, the Olesen family is still living with the consequences of this crime. We ask only that the court remember Eva Olesen, remember for the family she left behind, ensure that justice remains steadfast, accountable, and uncompromised after all these years. The Olesen family has waited long enough. Thank you for your consideration, Your Honor.
Thank you. Is that the conclusion of your own statement?
Yes, Your Honor.
And were you going to read Peter Olesen's statement?
I was going to read, yes, my father, Peter Olesen's statement on his behalf.
Very good. Would you like to make a record of the reason for his absence today?
Judge, I believe he didn't feel comfortable talking in court, and so he was asking that his son read it for him.
Is that correct, Mr. Olesen?
Judge, I also...
Your Honor.
Sorry.
Okay. Thank you. Go ahead.
I will read as a quote here. Dear Judge Pullen, for 41 years, the Olesen family has endured and felt the indignation of the proceedings of the Carter versus State of Utah without receiving closure. The trauma caused to the family by the murder, as well as the roller coaster proceedings after the incident, are beyond measure. To have Carter released on bond awaiting trial would only add to the emotional and psychological harm to the members of the Olesen family. To know he is out of jail, wandering freely and capable of a heinous acts puts the Olesen family in a vulnerable position. The security of knowing he will be confined while waiting trial is a guarantee for the victims that he will not be free to harm others and will stand trial. Carter would be a flight risk and a danger to the community because there is no incentive to stay and await trial. There is no incentive to abide by the law. Due to the seriousness of the charges, he has nothing to lose by running and hiding. He has confessed to his heinous acts and possesses no moral compass to abide by any laws or any restraints the court would place on him. He was fleeing the scene when he was apprehended and would again be a flight risk. He is without means or skills and could be an endangerment to the community by returning to the methods he knows best, robbing and killing. I respectfully ask the court to consider the humanity of the victims and safety of all. Sincerely, Peter Olesen, son of Eva Olesen.
Thank you, sir. You can turn off your camera, but we'll keep you in the proceedings, or you're free to go. It's up to you.
I will stand by, Your Honor, if you need anything. Thank you.
Okay, thank you. Do we have Eric Olesen remotely?
Okay. Judge, Eric's statement is going to be read by Erica.
Okay.
No, she's here.
Okay.
Right.
Who would you like to be next? Counsel, who would you want next?
Erica will read for
Very good.
Eric's statement.
Could I have you just come up to the podium here? If you raise your right hand, take an oath to tell the truth. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
And you're reading whose statement?
Eric Olesen, my uncle, the son of Eva.
Okay, would you like to make a record of why he's not here today?
Judge, I believe he's at work and was not able to make it.
Is that correct?
To my knowledge, yes.
Okay. Yeah. Is he on?
He might have been, Judge. I don't have that.
Okay. I just want to make sure he can hear if he's here. Yeah. Okay, he's on. Go ahead.
Okay. Your Honor, this quote, sorry. Your Honor, my name is Eric Olesen. I am Eva Olesen's son, and I was 14 years old when this horrific incident happened to my mother. I am concerned about the potential release of Douglas Carter, knowing that he is a threat to society. I am almost certain that he is not rehabilitated. He has signed a written confession and has been convicted not once but twice in the court system. He was convicted of a very heinous crime, and the chances of him being a habitual offender is very likely. The risk to the good people of Utah is substantial, and I strongly feel he should remain incarcerated for the rest of his life. His actions have consequences, and knowing what he is capable of doing is a major factor when you consider in giving him bond. Thank you, Eric Olesen.
Very good, thank you.
Gary Olesen would be next, Judge.
Very good. Mr. Olesen, if you'll come up to the lectern, please. Do you solemnly swear that the testimony you are about to give in the proceeding now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Go ahead.
Your Honor, my name is Gary Olesen. I am Eva Olesen's second son. Sorry. This is a very emotional time for me.
Would you be more comfortable seated?
I'm not sure.
Do you need to take a minute?
I think I'm okay now.
Okay.
Sorry about that.
That's all right.
My mother was taken from our family on February 27th, 1985 in Provo, Utah. The possibility of Mr. Carter's release brings renewed fear and distress to our family. I am here to express our strong and unified opposition to the release of Douglas Stewart Carter. While we understand that this hearing is not about determining guilt or innocence, we are deeply concerned about safety. Mr. Carter confessed to murdering my mother in her home, a place where no one should feel that one should feel safe. For over 40 years, his incarceration has protected our family and the community. The thought that protection being removed is deeply troubling. We're also concerned about the risk of flight. At the time of the crime, Mr. Carter left the state, demonstrating a willingness to avoid accountability. And this raises concern about where he would reliably appear for future court proceedings if he's released. And for this reason, I ask the court to keep Douglas Stewart Carter in custody. Thank you for considering the concerns and feelings of Eva Olesen's family. Thank you.
Thank you.
Judge, the last one is Teresa Olesen.
Very good. Good morning. Could I have you be sworn as well? Do you solemnly swear that the testimony you are about to give in the proceeding now pending before the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Very good. Thank you. Go ahead.
Your Honor, my name is Teresa Olesen. I am the daughter-in-law of Eva Olesen. Only 3 people in this courtroom today were present at the original trial in 1985. Mr. Carter, my husband Gary, and me. The moment I was told that Douglas Stewart Carter was asking for a motion to grant a condition for release, an immediate gut-wrenching sickness filled my soul. A heartache you feel when you know something is terribly wrong, a debilitating feeling of panic, anxiety, and stress that evokes a very real physical reaction in one's body. I am here to express my concerns about the release of Douglas Stewart Carter while the case is pending. The grief and heartache our family has experienced over the last 40 years are indescribable. Unless you have experienced this kind of loss, it is difficult to understand how deeply it continues to affect a family. On that horrible day in February 1985, a beautiful mother and grandmother was in her home, knitting a sweater for her youngest son's upcoming birthday. I want the court to remember that behind this case is a mother of 4 sons, a grandmother, and a beloved member of our family whose life was violently taken from her. For many months following Eva's murder, we, along with many Provo residents, lived in fear, wondering who could have committed such a horrific and violent crime. I also want to make it clear what the current situation means to our family. We are not here today because a court has determined that Mr. Carter is innocent of Eva's murder. Carter's confession includes things only the person who killed Eva would know. The Utah Supreme Court's recent decision concerned constitutional violations in the process of his original prosecution and conviction. The court determined that those violations prejudiced Mr. Carter and resulted in his conviction and sentence being vacated and a new trial being ordered. He has not been exonerated. That distinction is important to our family. The fact that we are back here 40 years later is not the result of a court finding that Eva's murder did not happen or that Carter was found innocent. It is the result of constitutional issues surrounding the original prosecution that now requires the case to be tried again. Once Carter was behind bars, our family finally had some measure of safety. For 40 years, we lived knowing that the person responsible for Eva's murder was behind bars. That knowledge gave us a measure of security. His release would take that security away and force us to live with a fear we have not had to face for decades. His potential release reopens a wound that has never completely healed and creates profound emotional distress and fear for our safety and the safety of others. I also have serious concerns about the safety of the community. Whatever amount of time has passed, the seriousness and violence of what happened to Eva have not changed. The passage of 40 years does not erase what happened to her or eliminate the risks that must be considered when deciding whether someone capable of that level of violence should be released. The emotional and physical damage is intense with the prospect of this motion going in favor of Carter. The very real threat of allowing him to expose innocent citizens and potentially our family or anyone else who might trigger Carter's emotions to his violence is unfathomable. I am also concerned that Carter might be a flight risk. 4 decades ago, Carter left the state of Utah. He has family and other connections outside of Utah. Given those circumstances, I have serious concerns that he may not remain in Utah. I do not know Carter's current mental or emotional state, and I do not pretend to know what care he may need. However, if there are legitimate concerns about his physical or mental health, I believe those concerns can and should be addressed while he remains in a secure setting. His well-being should not require placing our family or the community at unnecessary risk. I understand that the court must consider many factors in deciding whether Mr. Carter should be released while awaiting trial. I respectfully ask the court not to add another chapter of fear and uncertainty to a family that has already suffered for 4 decades. The possibility that Carter's release could result in another victim or another family experiencing the pain and loss that ours has endured is not a risk I believe worth taking. I respectfully ask the court to deny Mr. Carter's request for release and allow our family and the community to remain protected from the risks that his release could create. Thank you.
Thank you very much. Does the state rest?
Yes, Judge.
Any rebuttal evidence?
No rebuttal. There is just a proffer that if we can have just a moment to
Very good.
make sure we have it right. Your Honor, if we could take just a 5-10 minute recess while we formally, I just want to make sure that the proffer is accurate.
Very good. Let me know when you're ready. Court's in recess.
All rise.
They're okay with that. Yeah, but that's not what he's doing.
We were hiding it from you. It took you this long to notice
Yeah,
that?
it did. I'm not used to this courtroom anymore.
Traitor.
Media had a question about whether or not they could use the video and audio of the victim's family, or just the audio, or if judge has a limitation
I
on
think
it.
whatever's in the order, I think the orders are right there. You see there's a box that's checked?
Additional exclusions, electronic media, coverage of victims, family members, so they can't use it.
Okay. Can they use what is said? Okay.
Additional exclusions for this hearing, electronic media, coverage of family members. Do you want to take this?
Yeah. They have one, right?
They're the one that applied it, but that was what the judge signed.
Jennifer said they were ready, so they are. Jennifer said they were ready. I guess they're not. You guys are ready. Maybe Jennifer was ready.
If I was the attorney for KSL, I'd make a lot more money than I currently make. But I did let them know.
Okay, so as soon as we're done, I'm going to send this to Rick. And then as soon as we're done here, we can file the order, and then as soon as the judge signs it, we'll go.
Personally, I'd rather do it on Friday morning, too, just take care of it all in one day.
Yeah, absolutely.
What's today, Wednesday?
I think so.
Yeah, Friday morning would be better for me.
And then back by November. Results.
Hopefully. Adam, how you can do it.
That would be nice.
Judge is out on December the 10th.
11.
Yeah.
December 11th. So it'll be last month.
It'd be good to have it all done before, like, the playoff stretch in the NFL.
And that's not till January.
I know. But we got so many really old quarterbacks out there, we just don't know what's going to happen.
Did you guys hear Tim Curry died?
Who?
Tim Curry.
Oh, I saw that, yeah.
Dolly Parton yesterday, Tim Curry today.
Yeah, it's funny because I hadn't heard that Dolly Parton had died, but I opened up my Apple Music and the first thing that popped up was
Jolene.
no, it was Dolly Parton Essentials,
Oh.
and I was like, oh no, that means she must have died. And I started looking at the news. I'm like, yeah,
You know, she's pretty incredible.
it's amazing, absolutely.
She's truly amazing. I mean, they went through all of that and all.
Yeah.
She married the same guy for over 6 years.
It's insane, yeah. It's nuts. You know, she's worth like $650 million.
Dolly's, she owns.
Yeah.
Dolly, go that one. That amusement park in Virginia Beach.
I don't think so.
Maybe. I don't know. I'll be honest, my knowledge of Dolly Parton trivia is woefully lacking.
And then I guess in the end it was cancer.
Yeah, I guess so.
In the end it was cancer. She had like a short but very fast bout of cancer.
Her husband died like a year ago. Her husband died like a year ago.
Yeah, I think she's gone downhill ever since her husband passed away.
And it happens that way a lot though. It's pretty amazing stuff. They played clips of interviews with her so that when she was talking about that foundation that she had that provides books to kids, and she was talking about how her dad was illiterate and couldn't read or write, and that always bothered her. I'm like, wow.
I think she was super smart. business savvy.
Yeah, right.
Yeah, it's business savvy.
She was the Taylor Swift of the 70s.
That's a good analogy.
When we moved to Kansas, the first thing, like, because we had one kid every day, like 8, we gotta look in the mail. We don't look. It's crazy. Yeah.
I didn't realize that the literacy rate in the United States is only 79%. That means there's 60 million people running around out there who can't read and write. It's a lot, dude.
When I was in New Orleans, I was a TA to a guy who said that the New Orleans school district is pumping out just graduating classes of kids that cannot read. So they cannot read. So they get into college and they can't read.
Seems like it's real. That would be a problem considering you're reading like 4,000 pages a semester.
The other thing too is that the attendance that the kids are not going to school.
Yeah, that's true. It's going to have some real downstream effects for our society. After I'm dead, so it's okay. But these things will happen, 30 years from now, I'll be dead. So I can only care about it so much.
Let's talk about legacy.
Hey man, I only have so much empathy in my pie, you know? I used half of it up on my dogs.
Are you ready for tomorrow?
Yes. Knowing this was happening, I got it already on Monday. And I think that's stupid Kyler Ovard guy coming back for his training tomorrow too. So I'm getting ready to be annoyed. I think we should finish the morning session easily by noon. Yeah. I'm worried about the afternoon session. I think we'll be okay. It'd be nice to have that DNA and drive this thing forward.
That's what?
To have the DNA and drive this thing forward.
Yeah.
I feel like we've been on a holding pattern for so long.
Rick Stanger said, hey, don't know if you're aware, but KSL's live stream is going. It's not that you'd say anything bad, but it's being broadcast. I said, wait, right now? You can hear me talk about Tim Curry passing away? Yes. So everything that we just said. Good thing I didn't talk about my wife's shoes.
That's right.
You did talk about case overturned.
That is true. That's probably what it Well, no, they can live stream. They just couldn't live stream when the victim's family was talking.
I'm not familiar with any of those rules. You're much more familiar with those rules than I am.
Only because there was a piece of paper.
All rise.
Thank you so much. Please be seated. We'll go back on the record in the matter of State versus Douglas Carter. Mr. Carter is present. Would you state your appearances again for the record?
Thank you, Your Honor. Erwin Patilas and Stephen Jones for the state.
Neil Hamilton for Mr. Carter.
Very good. What proffer did you want to state for the record?
And I apologize, Your Honor. My understanding was based on what I was told by counsel. In speaking, we do not have a proffer to be made.
Thank you. Do you wish to argue the bail issue?
I do.
Go ahead.
It's a difficult argument to make because the feelings on both sides of this issue are 100% valid. In Mr. Carter's declaration, he talks about his feelings towards the Olesen family, and I want to emphasize those feelings. There's no ill will towards the family. They've lost their loved one, and there's no replacing that. There's no diminishing that trauma and that loss. In looking back, we all know that hindsight's 20/20. There are a lot of decisions that I think should have been made differently that hopefully could have avoided this. Provo PD should have never investigated the murder of the aunt of its chief of police. Detective or Lieutenant Pierpont should have never done the things that he did. The state should have never been involved in the perjury. This is what happens. There is the uncertainty. And for every exoneree, there's an unsolved crime. We're not here to diminish that trauma, but I think it's important to recognize that trauma. Mr. Carter has never expressed a desire to flee, then or now, from this case or these charges. The evidence in front of Your Honor is that Mr. Carter's family believed that the reason why he went to Tennessee in the first place was because of a different case. And then we have Exhibit 1, where Chief Nelson says they have no reason to suspect that Mr. Carter's flight then had anything to do with this case. There is no evidence that Mr. Carter wishes ill will towards anyone, whether it be the victim's family or it be anyone involved in the prosecution or the community. That evidence does not exist. I understand that people have strong feelings, and I'm afraid that those feelings are trauma-informed. And again, we have nothing but sympathy for what they have gone through and what they continue to go through. They deserve to have Eva's murder solved. But the fact of the matter is, the evidence, as it continues to evolve and develop, points to Doug not being that person. We have evidence that has been run against CODIS. Mr. Rogers testified that based on his training and experience, which is considerate, we have every reason to believe that that murderer's blood was left at the crime scene. And we have profiles taken from evidence connected to that blood. Those profiles have been compared against CODIS. Doug is in CODIS. There's no match. We acknowledge that that is not exoneration under the legal standard. That direct comparison needs to take place. We acknowledge that, and that is happening. But the fact of the matter is, there's never been any physical evidence connecting Doug to this murder. And now we know that there is physical evidence left behind from the murderer, and there's no match to CODIS. The only evidence that's ever been there is, the only evidence that remains is Mr. Carter's confession. And the record is clear that that's not Mr. Carter's confession. Detective Pierpont dictated that, and Mr. Carter assented. And Mr. Carter has been clear about why he agreed to that. I think 41 years is enough.
Thank you. From the state.
Your Honor, I just want to make clear one thing that defense counsel said, which is that there's no CODIS hit. 2 profiles were uploaded into CODIS. One of them was blood outside the crime scene. Another profile was uploaded into CODIS, which turned out to be familial DNA, which was eliminated by using Eric's DNA profile. So the fact that there's no CODIS hit is unpersuasive considering the multiple profiles of male DNA that were developed and that Adam Yankee testified to before the court. So I just wanted to clear that up. From a completely non-emotional standpoint, Utah law requires that in a capital case where there's substantial evidence, that the defendant is not entitled to bail. At this point, as we speak.
That's a discretionary decision still, correct, under
Absolutely, Your Honor.
recent Utah case law?
Absolutely, Your Honor.
Okay.
And so, however, as we stand here today, no court has found the confession inadmissible. So as we stand here today, the confession is admissible, and therefore there is substantial evidence against the defendant. If that should change, I'm sure they can renew their bail motion. But until then, the law of the case is that that confession is admissible, and therefore there is substantial evidence of the defendant's guilt in this case, and it's a capital case. Therefore, as a matter of law, with consideration of the court's discretion, of course, the defendant is not entitled to bail.
Thank you. To be clear, the state is requesting that Mr. Carter be held without bail, correct?
That's correct, Your Honor.
Pursuant to Rule Section 77-2201.
Correct, Your Honor.
The constitutional provision which authorized the legislature to decide the terms under which a person can be held without bail, correct?
Correct, Your Honor.
Very good. Anything further from Mr. Carter?
No.
Thank you. The court has taken detailed notes of the testimony and evidence presented today. I want to take some time to review those notes, and I will issue a written decision on the bail question. Counsel, if we could just now maybe shift to a pretrial conference format. We have some motions that have been filed that are not fully briefed. I'm just wondering if maybe some have been fully briefed. I just would like to get those on for disposition. If they are, where are we?
Your Honor, I think I need to have discussions with my superiors about the motion to compel with regards to the lab and the evidence or the notes that defense is seeking. I don't know what else is outstanding.
We filed a motion to compel last night regarding multiple discovery requests that I think we need to either have a response or that we have not received a response on.
And Your Honor, I haven't checked my email since yesterday afternoon, so I haven't seen that.
So I've got a motion and order to compel, which is docket 270, and then one filed just last night, 287. Are there any other motions that are outstanding?
Not yet, but there will be, hopefully within the next few weeks. We're working on a motion to strike the death penalty due to due process concerns, as well as concerns for Mr. Carter's right to a fair trial. That is getting close to being filed, but it has not been filed yet. It will be filed soon.
Very good. So I appreciate that review of the docket. I just wanted to make sure that we're moving motions to disposition expeditiously. We also talked about scheduling a trial date. Are you prepared to do that?
Yes.
Do you have a sense for how long the state would need?
I believe it would be 30 court days, Your Honor.
A week to pick a jury, is that what you're thinking?
A week and a half to pick a jury, Your Honor, considering the death qualification. And then the rest of the time for evidence.
And is that solely for the state's case?
You know, I was building in some pretty lengthy cross-examination, as I imagine the cross-examination will be full-throated and enthusiastic. I didn't build in very much time for the defense to put on a case in chief, so if the defense has opinions on whether my estimate is adequate, considering their case in chief, I certainly defer to them.
Mr. Hamilton?
In putting our heads together, we figure we'll be calling at least 14 witnesses through the case in chief, as well as, you know, if it goes past the case in chief into mitigation. I do anticipate that we would have several experts testifying regarding the DNA.
Mm-hmm.
So I would say we would have 18 witnesses. Several of them are going to be full-day witnesses. In all, I would think we would probably need 2 weeks.
Okay. When can you be ready?
December?
December of 26, you're saying?
I don't know if that's workable, but I mean, this is a case where we were going to clear our schedules for.
Mr. Jones is not available in December, and I think there are a lot of moving parts that need to be considered. Unfortunately, Mr. Jones, Mr. Reichman, and I also have another murder which is going in March. Considering the amount of days that we would need, and I think considering Mr. Hamilton's statement, I think you'd be more comfortable with 40 days rather than 30, correct?
Sure.
And so if we could look for 40 days and see where that puts us.
We need to, this would be priority over everything we've got set. So we can look into January.
So by my calculation, that would be 10 weeks.
Basically, yeah, what we would need is 6 weeks for the state, a week to seat a jury, 5 weeks for the state, and 2 more weeks for the defendant.
So 8 weeks?
Mm-hmm.
Because we won't be doing Tuesdays.
Right. Someone else will take the calendar. We will be doing two.
Oh.
Yeah, I won't have my felony law in motion calendar on Tuesday. Someone else will have to take that.
Okay.
Yeah, so we'll keep them all.
Judge, will this be you or the new judge taking over on the 11th?
Well, it could be me, but we would have to start trial November 1st, which I'm happy to do if that's what you would like to
I don't
do.
think we can be ready at that point, Your Honor.
It's 2 months away. I don't know that the crime lab is going to, I hope the crime lab will move on this. This should be priority
Absolutely,
for the
Your
crime
Honor.
lab.
I completely agree, but I have no control over.
Judge, can we approach real quick?
Sure. Let's go in chambers so that we can have the court reporter. We'll be in recess.
All rise.
Could I have you back in chambers?
guys can relax.
All rise.
Thank you. Please be seated. We will go back on the record in the matter of State versus Douglas Carter. He is present. Would you state your appearances for the record?
Erwin Patilas and Stephen Jones for the state, Your Honor.
Neil Hamilton for Mr. Carter.
Thank you. I've met in chambers with counsel. Scheduling a 2-month trial will require me to look carefully at the future availability of the judge who is chosen to replace me. That's going to take me a minute, and so I'm going to issue I'd like to have time to go through the calendar, both my own and the future, and I will have the clerk send out a notice of the trial dates, and that way we block out 2 months. I've also discussed with counsel the importance of that trial date being firm. I don't want to schedule a trial date only to have it continued for some unforeseen matter. And so, or for any foreseeable reasons. And so we're trying to deal with that. There's a lot of moving parts. We need to assess the availability of expert witnesses. And then also build into this schedule time for Mr. Carter's own DNA experts to do their work. With those moving parts, I've considered those. I'm going to go through the calendars. The clerk will issue a notice of the trial dates. That should come out as early as, as no later than Monday. Could be earlier than that.
Thank you, Your Honor.
Is there anything else today?
Yes, Your Honor. While we were dealing with the DNA motion, the court asked me to write an order. I wrote an order during the bail motion, and I showed it to defense counsel. Defense counsel approves. Mr. Hales is going to coordinate with an evidence tech to take the swabs either Thursday afternoon or Friday morning. I've got that order in my email right now, and I'm going to send it to my legal assistant to have it e-filed, so the court's request will be taken care of shortly.
Very good. You've read the order, Mr. Hamilton?
I have read the order, and I am available tomorrow. I'm not available Friday, but we'll make, someone will be there.
Okay.
And, Your Honor, perhaps we could have Mr. Hales and the defense exchange numbers so that they can properly coordinate.
That would be great. I will sign the order when it's filed.
Thank you very much, Your Honor.
Anything else?
No, Your Honor.
Thank you for your work. Court's in recess.
All rise.
All right, man. Open.
Michael, you want me to give you these? They're the letters, the statements?
You can e-file them
Okay.
under character.